Item for pronouncement of judgment. Item number 36, RSA 71 of 2015.
Appeal dismiss.
Any
mention?
May I please, my lord? I beg to mention item number 3, my lord.
Yes.
Kindly matter may be adjourned for 2 weeks, my lord.
On the prayer being made by Mr.
C. Sarma.
Learned counsel for the petitioner, SSL is the matter after 2 weeks.
For the respondent lordship, the name of my senior, Mr. S.P. Roy, is not reflected in this map. Item 3.
Next that we will consider it. Since we are not taking the matter today, we will consider your prayer on next date.
Highly obliged.
May it please your lordship, I beg to mention two MSA lordship not listed in last 3 years. 2015 matters, my lord.
When do you want?
My lord, in December, the second week of December.
Okay.
Much obliged.
May I please your lordship? Lordship, I beg to mention item number 40. The LCR has not been received yet. That may be called upon lordship.
40.
Yes, lordship.
Your good name?
F.H. Laskar.
Mr. F.H. Laskar, learned counsel for the accused, submits that LCR has not yet been received, and as such, the matter may be listed after
December, lordship. December.
December. When?
On 4th December.
4th December. Races shall issue reminder to the learned trial court for transmitting the scanned copy of the record without further delay. Yes.
Well, the items 41 and 42 of today's supplementary list.
Yes.
41 matters. Well, I have to file the amended memo of appeal. Therefore, I pray that these matters be taken up on 3rd or 5th. I have to file the amended.
When?
The substantial questions of law.
When?
No, 3rd or 5th of December.
On the prayer being made by Mr. A. Ganguly, learned counsel for the appellant, races shall list the matter, both the matter, 41 and 42, on 3rd of December.
Right. And I have one more prayer. I have an early hearing application that may be taken up on 5th, subject to lordship.
5th of December.
5th of December.
May I please, lordship? My lord, item number 12, my lord. My lord,
Yes.
because of some personal difficulty, my lord, I have to leave the court early, my lord. That may be taken after 1 week, my lord. Item 12, my lord.
Yes, on the prayer being made by Mr.
A.H.M.R. Chaudhary.
A.H.M.R. Chaudhary, learned counsel for the petitioner, races shall list the matter. When?
After 1 week, my lord.
After 1 week.
My lord,
Prayer.
another prayer in respect of item 33, my lord, with due consent of other side, my lord. This matter also may be taken after 1 week.
Let's see, in this case, I am appearing for the respondent. Let's see.
Yes.
Let's see, respondent has also filed amended method bill. Let's see, that is 23 of 2024. So both matters may kindly be listed together. LCR has been received, let's see.
Okay. As agreed by learned advocates of both the parties, races shall list the matter. When, Covid?
On 13th
13th.
December.
13th. It is submitted that another Met appeal,
Let's see.
being Met appeal number 24 of
23 of
2024 is also pending between the same parties, and same may be also tagged with the present Met appeal number 26 of 2024. Race is directed to list both the matter on next date.
One part had to be metal lordship, it was part of by lordship. Last time lordship, it was listed on 5-8 lordship. After 6 years lordship is not in the clear base. Lordship matter is not listing lordship.
What matter?
Matter is linked to lordship maintenance lordship. Letters matter of hardware lordship several times lordship.
No, that matter was released from this court.
Not released lordship. That is also not
Other side, in the other side, Mr. Talukdar was there.
No, no, Mr. A. Hussain is there, Lordship.
A Hussein,
Yes, Lordship.
second.
It is not listed. So it may be listed and thereafter.
Next that fixed one,
Fixed on asset. It was listed after, directed to be listed after 10 days. Since about 4 months of the gone, Lordship, but they're saying since the Lordship in the tribunal bench.
Court master will check it.
Yes, Lordship.
May it please Lordship, Lordship, I beg to mention item number 38 of supplementary cause list.
Yes.
My humble prayer is, Lordship, one affidavit in reply was filed thereon
Hmm.
to requisite that affidavit on thereon.
Today.
Yes.
Okay, call it. Yes.
Lordship, for listing one RSA for hearing
When?
any day in January, 68, 2016 case.
Correct.
hearing in the month of January.
January.
Any date, on any Thursdays or Tuesdays, give any Thursdays or Tuesdays. For motion, item number 1,
May I please, your Lordship?
Hmm.
My late in this case, impugn order dated 12/4/2024, filed by lawyer civil Kolkata, staying the further proceeding of TS number 38, 23 order. And it's page 4, my lord, annexure 5,
Hmm.
this is the impugn order.
Hmm.
The Your Honor, find case 13, suit, my suit was filed, my lord.
Hmm.
Suit for declaration of permanent injunction only may be paid to Alman. Now, suit land is only desettled land, my lord.
Hmm.
2 bigger, 2 cut up, 10 lesser. Dag number 373, dag number may be paid to and boundary of may be paid to my lord. And it may be compared with another TS which shown file earlier. Case number 35, my lord. File the respondent.
No, you tell me, is the subject matter of both the suits are different?
The subject matter different. Our Switzerland is the area different, 1 bigger, 2 kata, 10 lesser, and their Switzerland is only 2 bigger, my lord. And out of total 7 bigger.
Where is your first client?
Claim I was showing you, my lord. My client is there. This is case number, my lord, 13. My client. Annexure 1.
Hmm.
Schedule below page 23 may be placed, my lord.
Hmm.
Switzerland, out of total 7 bigger, 3 quarter, 10 lesser.
Hmm.
There's many land, more land. So desettled land is my Switzerland. Only 1 bigger, 2 quarter, 3 lesser.
Hmm.
Also, dag number same, my lord. Pata number is also. But now, Your Honor will find case number 35. Suit of the respondent, case number 35, and table relevant portion, page number 40, my lord. Their Switzerland of defendant, of respondent, that means previous suit, schedule B shown only 2 big of land. Out of total land they have shown, but total land not shown in my lord. Total land 2 big are shown, Excel that is not. Yes, schedule may be period. Total land is there. 7 bigger, 2 quarter tells it.
Okay, we will issue notice at this basis.
My lord.
Heard Mr. B. Hussain, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 12/4/2024 passed by the learned civil judge, Junior Division number 2, Barpeta, in title suit number 38 of 2023. This to be noted here that by the impugned order dated so and so, the learned trial court has stayed has allowed the petition number 1028 of 2023 filed by the respondent herein. and state the suit of uh, uh, title suit number 222 of 2022. Peruse the petition and the documents placed on record, and also peruse the impugned order dated so and so. Let notice be issued returnable in 4 weeks that be taken by registered post with AD and also by usual
Well,
process.
petitioner plaintiff
Today.
suit number is PS 38/23. Interim prayer also there may be further proceeding.
No,
at the state
no, let the other side appear.
March.
Let the other- Interim prayer will be considered on the appearance of the other party.
Item number 2.
May I please, yours.
Mm.
This is a landlord and tenant dispute. Lord.
This is a revision petition
Yes, Lord. Sir.
against the judgment of First Appellate Court.
Yes, Lord. Sir.
Okay.
Initially, the title suit filed by the landlord,
Mm.
landlady was dismissed by the trial court, Lordship.
Mm.
Subsequently, on being appeal, the
Mm.
First Appellate Court had decreed the statement. Against that, I have preferred the revision petition.
Okay. Heard, Mr. Your good name?
Sharma, Lord.
R. Sharma, learned counsel for the petitioner. In this petition under section 115 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the judgment dated 6/9/2024 and the decree dated 3/10/2024 passed by the learned civil judge senior division number 3 Kamrup M. Guwahati in title appeal number 19 of 2019. It is to be noted here that by the impugned judgment dated so and so and the decree dated so and so, the learned First Appellate Court has reversed the judgment dated 15/6/2019 and decree dated 21/6/2019 passed in title suit number 83 of 2015 by the learned Munsif number 1 Kamrup M. Guwahati. Peruse the petition and the documents placed on record and also peruse the impugned judgment dated 6/9/2024 and decree dated 3/10/2024 passed by the learned civil judge senior division number 3 Kamrup M. Guwahati in title appeal number 19 of 2019 and also the judgment dated 15/6/2019 and decree dated 21/6/2019 passed in title suit number 83 of 2015 by the learned Munsif number 1 Kamrup M. Guwahati. Admit, issue notice to the respondent returnable in 4 weeks that be taken by registered post with AD and also by usual process within a week from today. SSL call for the record from the learned courts below. List the matter after 4 weeks.
There is an interim prayer.
Interim pair will be considered on next day.
Also,
Returnable.
execution, there is a reapprehension of filing the execution case laws
When?
before the trial court laws.
When?
But
When file?
then I am apprehending that they will file.
If they file, you mention the matter before the court, we will consider.
Item number 4.
Please, your lordship. It is a title should file, if money should file against me, I am a transporter. For some, there is, on the ground that there is some contributory negligence from our part. Whereas the party has already got the basing from insurance company. Now, insurance company has filed suit against us, but on a very belated date they have filed. Whereas the limitation only for they should file within 3 years, but it was completed 4 years. By filing, by then it was filing date was 14.
No,
12,
by the impugned order, the trial court
Yes, madam.
has refused to frame preliminary issue.
It is,
on the point of limitation.
yes,
But that can be considered at the time of hearing also.
yes, my lord, that's why I want.
At the time of the delivering judgment also.
Yes, my lord, that's.
You will got an opportunity to argue the matter on that point also. Because this limitation is a mixed question of fact and law.
My lord, until and unless this issues is framed, how will argue on that point? That issue may be framed, that is our prayer, that's our prayer. This is as per that is order 14, rule 5 says, there is no, at any moment can be filed this, and any moment this can be, issue can be, court may at any time before passing a degree, amend the issues or frame additional issues on such terms as it thinks fit, and all such amendments or additional issues as may be necessary for determining the matters in controversy between the parties shall be so made or framed. So,
No, you saw how this impugned order is illegal and arbitrary.
because issue is not framed yet, that's. That is, issues are framed, but preliminary.
So,
issues are
but the
framed.
case is in the stage of cross-examination of the PWs.
Yes, ma'am. But not yet cross-exam, not even.
Maybe, but you show me the issues which were framed by the learned trial court.
Yes,
Where?
long back it is filed.
No.
Yes, madam.
When the issues were framed by the trial court
Before filing the evidences,
before filing, where is that issues? Shows me.
issues are not with me. If the record may be called for.
No, you will not call for the record. You produce the certified copy. We'll see whether any issue has been framed on that point or not.
Exactly. Scan copy may be called for. That will be. Scan copy called for.
Pardon me, sir.
We get a.
Learned counsel for the petitioner. List the matter on when?
After 4 weeks.
After 4 weeks. In the meantime, Registry shall call for the scan copy of the record from the learned trial court.
This is maybe state that further procedure.
No.
Item number 5.
Your Lordship. The petitioners are plaintiffs, Lordship. Their suit is pending at the stage of submission of evidence of the plaintiff side, Lordship. At this stage, Lordship, plaintiff number 2 and 4 died. They filed substitution application, and later on one condonation application that was rejected. Lordship has already disposed of one matter, Lordship, if your Lordship remember. Between the plaintiffs are same, but defendants are different in that case, Lordship. At the motion stage, your Lordship has allowed to file an appropriate applications, Lordship. And this is a second suit between the plaintiff and some other defendants, Lordship. Impugned order is at page 49. Page 50 is the relevant portion, Lordship. Third paragraph. Record shows that the suit was pending at the stage of evidence of PWs. From the petition number 223423 under order 22 rule 3 CPC, it appears that the plaintiff filed the petition stating that the petition number 223423 was filed within time. But thereafter on 11/3/2024, the plaintiff filed the petition under section 5 of Limitation Act by admitting that the petition number 223423 was filed after the period of limitation, which are itself contradictory. But in fact, Lordship, in first petition, they have stated that as per Supreme Court, there is a limitation, lordship, exemption of limitation. And when they came to know that in fact there is a delay, lordship, so they have filed subsequently one delay continuation petition. In this case also, I have filed, lordship, the setting aside abatement application was not filed. So if your lordship grants such liberty to file appropriate application, lordship, as your lordship has considered in that CRP, lordship,
Liberty to file.
appropriate application, lordship. And because here also, lordship, they have filed
Heard Miss R.S. Sodori and Learned Counsel.
Archer.
R. Sodori, Learned Counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 27/8/2024, passed by the learned civil judge,
Civil Judge, Junior Division, North
Civil
Salmara.
Judge Junior Division, North Salmara, Abhayapuri, entitled suit number 186 of 2021. This to be noted here that by the impugn order dated 27/8/2024, the learned trial court has dismissed the petition number 2234 of 2023, passed by the petitioner for substitution of legal heirs of the, this is plaintiff number 4 and plaintiff number 2. So this a legal heirs of
Four lordship need not to be substituted as already the other plaintiffs are her legal heirs, lordship.
mm,
4 is mother, so lordship, her name was required to be struck out from the plaint, lordship. That prayer was made in the petition, page 42, annexure 4, and plaintiff number 2, lordship, after his demise, his legal heirs are not cooperating, so a prayer was made to make them party as pro forma dependent.
where is the petition?
Page 42, lordship.
Which paragraph?
Paragraph 2, that the plaintiff number 4 has expired and her sons and daughters are already in the record as plaintiffs, and therefore there is no need for substitution. The name of plaintiff number 4 is therefore required to be struck out.
So this is the petition number 2234.
Yes, Lord.
Ms. Sodori submits that substitution of legal heirs of plaintiff number 4 is not required as she is represented by the other plaintiffs,
Other plaintiffs, Lordship. or
other
sons and
plaintiffs
daughters
who are there, who are her sons,
and
and
daughter.
the legal heirs of respondent number, no, plaintiff
Plaintiff
number
number
2
2.
are not cooperating, and as such, they may be respondent, they may be, the legal heirs of respondent number 2 may be arrayed as pro forma respondent, pro forma respondent.
They may be substituted as pro forma dependent in the suit, Lordship. Both-
Pro forma defendant in the suit. Any other pair in that petition?
No, Lordship. Thereafter, Supreme Court limitation exemption paragraph was there, paragraph 6, Lordship.
And that the said petition could not be filed in time, and that the substitution petition could not be filed in time, and there was delay, and thereafter a petition under section 5 of the Limitation Act was also preferred.
Annexure 5 is 46.
And the same was also dismissed by the learned trial court.
Page 51, last paragraph. Both the petitions are rejected.
So when the person concerned died,
Lordship, the date specifically, they cannot state as because the
then the limitation from who is that limitation will be counted.
Lordship, now I have advised them that from the Qabristan, they should obtain a certificate, Lordship. From that, they will come to know that what date he expired, Lordship. In fact, there is an enmity between both the brothers, Lordship, arises after filing of the suit. So, the appropriate applications will be filed, and if it is filed within the period, Lordship, after remand, Lordship, then that may be considered in accordance with law, Lordship. Lordship has already granted that relief in CRP 479, Lordship. Same plaintiffs, only dependents are different.
And that on account of some fault on the part of the engaged counsel, the petition could not be filed in time. And that the petitioner may be granted liberty to file appropriate application, and the learned trial court may be directed to consider the same in accordance with law. But having heard the submission of Ms. Chaudhary, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record, and also perused the impugned order dated 27/8/2024. For taking note of all the facts and circumstances, this court is inclined to allow this petition, granting liberty to the petitioner to approach the trial court again by filing an appropriate petition, and in the event of filing such an application, the learned trial court shall consider the same in accordance with law.
It's 27/8, Lordship.
Next, that is
Number 6,
Date, Lordship.
when next that is fixed.
27/9, Lordship, and it was earlier, but now next date, Lordship. Within 15 days of Lordship.
Within a period of 15 days.
I'm deeply upset.
item 6.
May I please, Lordship?
Mm,
It is an application, Lordship,
mm,
filed by one of the parties before the learned trial court, particularly the family court, Your Honor. The impugned order may kindly be seen at page number 130.
mm,
When the matrimonial suit is pending between the petitioner as well as the respondent number 1 before the learned family court, Guwahati, Your Honor,
mm,
so far to decide their matrimonial status, that is a wife, who is in fact wife of the deceased husband.
mm,
During that time, Your Honor, what's happened, the respondent number 1 filed a suit, Your Honor, by learned civil judge Guwahati, Your Honor,
mm,
seeking property of the deceased husband, Your Honor.
mm,
And accordingly, we filed an application, Your Honor, seeking jurisdiction of the civil court when the matrimonial status is pending, yet to be decided, Your Honor. Lordship may kindly see page number 130, raising jurisdiction of the court. When the issue itself is decided, yet to be decided, Your Honor, so far the status of wife, who is in fact wife, whether the petitioner is the wife or the respondent number 1 is the wife. If until Your Honor, that issue is determined by a
so
competent
that
civil court, Your Honor.
title, that suit, number of the title suit was 506 of 2022.
Yes, 506 of 2022, yes. That has been filed, it is annexure, Lordship may kindly
Now, how this title suit is related to
the property of the deceased
family
husband,
court?
property of the deceased husband. One wife has filed this petition, Your Honor, seeking the entire property of the deceased husband, Your Honor. So far, her status is yet to be determined by the competent civil family court, Your Honor. This issue is yet to be decided, Your Honor, who is in fact wife of the deceased husband, Your Honor. And that's why we have filed an application seeking
No,
basic jurisdiction.
no, you come to the pair of the title suit.
Yes, yes.
What is the pair?
Here, page number 48.
Hmm.
Page number 48, Lordship. Page number 55 is a relevant page. Page number 55 is the where prayer portion is there in the title slip. Declaration of right title interest of the plaintiff number 1. Plaintiff number 1 is the respondent number 1, and plaintiff number 2 is her minor daughter. For cancellation of sale deed, and also issue precept to the sub-register of Guwahati, Your Honor, and also in the alternative she has prayed for specific performance of contract. Your Honor. When the status of husband is yet to be decided, whose husband? Whether petitioner's husband, whether respondent number 1's husband, Your Honor. That issue is to be decided first, Your Honor. Accordingly, we advance argument before the civil court, Your Honor. But civil court, instead of deciding that, Your Honor, came to finding that yes, civil court has the jurisdiction to decide the property dispute. But whereas the family matters can be easily decided in addition to the property dispute under section 7, Your Honor. Even if property related dispute arises between the parties, then it can be easily filed before the family court, Your Honor. Family court has the overall jurisdiction on the under section 20 also. And it has jurisdiction, appropriate jurisdiction under section, because Guwahati has the civil court, Guwahati has the family court, appropriate competent jurisdiction court is there under sections A, subsection A, B, C, D. These are related to the properties of the either parties, Your Honor. If any dispute arises between the parties, Your Honor, then the family court easily decided this thing. In case of this prayer of the property also, who is in fact the legitimate claimant. Family court has a jurisdiction under section 7, and it has overriding jurisdiction also.
You see, the relief claim in this in the title suit,
Yes. Sir.
can the family court grant these reliefs?
So far, the prayer of injunction is concerned, Your Honor. Injunction can easily be granted under section 7, subsection
No,
3.
no, here, not
Lordship-
only injunction, some other pairs are also
Also,
there.
prayers are also there. So for the
Already that family court act.
Lordship may kindly see section 7, it is clearly mentioned here that where all the jurisdiction exercised by district court or the subordinate civil court under any law for the timing in force, any law for the timing in force in respect of the suit and proceedings, the suit and proceeding of the following natures are to be determined. Suit proceeding to a declaration as to the validity of a marriage or the matrimonial status, suit or proceeding between the parties to a marriage with respect to properties of the parties, or either of them, should respect an order of injunction. They are raising question that they will not get injunction from the family court, but family court has ample power under section 7, subsection D, Your Honor. It can even grant the injunction also if there is any apprehension is there so far the interest of the properties are concerned. A suit or proceeding for an order of injunction, or suppose a suit or proceeding between the parties to a marriage of the properties of the parties or either of them. Suit or proceeding for a declaration as to the validity of a marriage as to the matrimonial status. Matrimonial status is yet to be determined, Your Honor. We filed this suit, matrimonial suit in the year 19. They subsequently filed this suit in the year 2022, Your Honor. So as to frustrate our attempt, who is in fact wife. So for section 20 is concerned of the said act, provisions of the section have
No, you
notwithstanding
come to section 7.
section 7, yes, Lordship. Subject to the other provisions of this act, a family court shall have and exercise all jurisdiction accessible by any district court or subordinate civil court under any law for the time being in force in respect of suits and proceeding of the nature referred to in the explanation. Suits and proceeding referred to in this subsection are suits and proceeding of the following nature. Namely, a suit or proceeding between the parties to a marriage for a decree of nullity. It is not applicable here. A suit or proceeding for a declaration of the validity of a marriage. That validity of the marriage of the other side has been raised question. Their marriage
Where?
certificate is in our matrimonial suit, Your Honor.
No, in this title suit.
In this title suit, they are claiming the property of our deceased husband, Lordship. Both parties deceased husband, Your Honor. Who is in fact wife, that is yet to be determined, Your Honor. The suit or proceeding of a declaration as to the validity of a marriage or as to the matrimonial status of any person.
Is there any pair in this title suit?
Yes, we had title suit.
Here.
in the title suit, they are claiming right title is exclusive right title interest. Your Honor, at the same time, in the alternative, they are claiming specific performance of contract, raising one issue that during the lifetime of a deceased
No,
husband.
no,
he
you
had
show
entered-
me whether the family court can grant specific performance of contract.
It cannot grant, Your Honor.
Then,
It can rather grant the injunction. If there is any alienation, is there any strong apprehension is there, then I may take away entire property of my deceased husband. Rather, it can grant the injunction. Subsection C.
From section 7,
Yes.
you show me whether the family court can grant any of the relief being prayed for in the title suit.
Lordship, a suit or proceeding between the parties to a marriage, properties of the parties, properties of the parties. I am claiming it is my property, they are claiming it is their properties. And rather, his property belongs to our deceased husband. And that status, who is in fact wife in this art, it is yet to be decided on. And subsection C, D says, a suit or proceeding of for an order of injunction. They can claim injunction also in respect of the properties out of the matrimonial relationship. Subsection C
Where,
and subsection
where it is stated about
it is
properties?
a C, subsection C, Lord Simically C. A
Ah.
suit or proceeding between the parties to a marriage with respect to property of the parties or either of them, They are claiming their exclusive right. I am claiming that our exclusive right. Our counterclaim also behind the suit. And subsection D states the suit or proceeding for an order of injunction. They have claimed injunction also. In the circumstances arising of the matrimonial relationship. 7, subsection C and D. These are under this section.
So here there is fair for this specific performance of the
contract
contract
also. Yes,
of the
yes.
sale deed.
Yes.
So if the family court cannot grant us relief, then
Yes.
what is the option available for the parties?
Lordship, if this sort of prayer cannot be granted, they cannot go for without determining the status of wife. Who is in fact wife, legitimate wife or legit person.
No.
That issue is
there-
determined since the days of
no.
19.
Is
Since the days of
there any
19.
pair in
That
the
suit is
title?
subsequently filed, Lordship.
You show me. Is there any such pair in the title suit?
Yes. Alternatively, they have claimed alternative prayer. At the same time, recovery of possession is there. Recovery of possession. At the same time, permanent injunction. They are seeking permanent injunction also. If there is permanent injunction, temporary injunction can easily be granted so far the interest of the properties are concerned. Your Honor.
Then what would happen the pair of this specific performance of contract?
Specific performance of contract, Lordship, provision itself is have the jurisdiction. Initially, they mentioned here there under section A, have family court have jurisdiction exercise, all jurisdiction accessible by any district court or any subordinate court under any law. Under any law for the timing in force. It may be the specific relief act also, Your Honor. Any law for the timing in force. And so far as section 20 is concerned, also may kindly see. Overriding effect. Section 20 is the overriding effect. The provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the timing in force or any instrument having effect by virtue of any other law other than this act. This act has the overriding effect. When the entire issue is pending, they can file their subsequent reliefs or subsequent prayer before the competent family court, Your Honor. When the matrimonial issue is yet to be determined, Your Honor. That's why they have the family court has ample jurisdiction. Civil court has no jurisdiction. We have raised this question, Your Honor. But our prayer was rejected, Your Honor. When the courts itself has no jurisdiction.
You show me any authority whether family court can grant the relief of specific performance of contract in respect of sale deed or not.
Lordship, here it is mentioned any law.
You show me.
Under any
Is
law
there-
for a
is there-
timing in force.
Is there any authority on this point? I will grant you time, 1 week time.
Yes, Lord. So one time I will give you. I give the citations also.
List the matter on
Next week, Lord.
next week. Kobhi, suggestion.
On 9th December.
9 December.
9th of December.
So as to enable the learned counsel for the petitioner to show any authority as to whether the family court can grant any relief of specific performance of contract.
Obliged.
Item 7.
I have challenged in the petition the order dated 15/7/24. Before going to the impugn order line, I would like to state the facts behind passing the impugn. I have filed a title suit seeking right to interest and declaration for recovery of possession. During the pendency of the trial, the defendant number 3, that is the present opposite party number 3, has filed application before the learned trial court below by stating on 25/7/2014, page 45, that except the similarity of having his name, there is no similarity about his father, etc. Accordingly, he prays for striking out his name. Now, thereafter, he adduced evidence in due course of trial. The question as relates to his appearance as well as participation in the suit, which is related to the sale deed, basing on which I have claimed the right title interest and have filed the suit. Now, Lordship may take note of the impugn order, which is at page 56. I have filed a petition number 1312/2021. I have sought for the relief.
So that person
The same
is of
person,
a doubtful identity.
my lord. This is the core.
So unless and until
Yes.
it is established that he has the authority to sell the land in question,
Yes,
what purpose will be served?
yes. That is why, my lord, I have, my lord, challenged this impugn order, because of the fact the issue involved in the said petition was not as such. The Koilastumu, son of Ganesh Miki, and Koilastumu of another person is two different persons. That was not the issue, my lord. Issue involved in the said petition was that the signature put by said Koilastumu is similar to the signature appeared in my cell deed. To find out the authenticity of the signature put by said Koilastumu, who appeared in this case, so is similar with the signature appeared in my cell deed. That is the issue involved in the said petition. But that part has not been considered by the learned trial court below. The learned trial court below has considered only the fact that there is some dispute as regards to the identity of the person. My lord, my submission before us is such that I have submitted the sale deed, I have filed the suit, I have stated specifically that this Koilastumu was the vendor of the plaintiff. He put the signature, and when he denied that I have not put the signature, then the respondent number 1 and 2, who has no locus standi at all, the respondent number 3 has not made any objection, my lord. My lord, my submission.
Mr. Sharma, let notice go at this.
May I submit you?
Let notice go.
No, that's true, my lord. May I submit you? If the signature
No,
of the
we will pass
Koilastumu-
order after hearing both the side. Let the other side appear.
May I submit, my lord? The case is fixed for argument. If my case is, my lord, not heard before argument, my lord, then, my lord, my purpose of approaching this honorable court will be frustrated.
Okay, we will stay it till appearance of the other
My
side.
lord.
Heard Mr. Sharma, learned counsel for the petitioner. In this petition under Article 227 of the Constitution of India, the petitioner has put to challenge the correctness or otherwise of the order dated 15/7/2024, passed by the learned trial court in TS number 231 of 2014. This to be noted here that by the impugn order dated so and so, the learned counsel, the learned trial court has dismissed the petition number 1312 of 2021, filed under section 151 CPC, for directing the performer defendant number 3 to put his signature in Assamese and English, and also in petition number 3469 of 2014, dated 25/7/2014, before the court in Mizje case number 269 of 2014, entitled suit number 231 of 2014, and to send the same to the forensic laboratory, Kailipara, for expert opinion. Where is the petition and the impugned order dated 15/7/2024? Let notice be issued to the respondent, returnable in 4 weeks. That be taken by registered post with AD and also by usual process within a week from today. Mr. Sharma, learned counsel for the petitioner, submits that the learned trial court has fixed the next date on 22/8/20. That date is already over.
Now, 27/2/2025 is the next date. On 16/11.
27.
27/2/2025.
So before that, we can dispose of the petition.
Till then, my lord, till returnable that the matter will stay. Trial court proceeding will stay.
Why?
My lord, winter vacation is coming, my lord. Then my lord, BU vacation is also coming. That is why, my
No, we will fix short date.
lord, so far that
You serve notice by Dusty Mood also,
so
if
far
possible.
serving of notice upon the respondent is concerned, my lord. In trial court also, my lord, he refused to accept, my lord. After several times, we put on the serve. That is why, my lord.
No, if you could not serve the notice, we will fix a short date. If you could not serve the notice upon him, then we will consider your pay.
If the matter is disposed of prior to 27/2/2025, it will be better.
Yes, we will try.
If it is not, my lord,
It is
disposed of
upon you to
prior to
cause
that,
service of notice upon him.
till my lord, returnable date, my lord, if it is
No,
paid-
next date we will consider. Upon the like that.
Winter vacation is also coming, my lord. From 9.
Itu kata dia tu लिखा list the matter on कब 3rd week
Yes, Lordship, on 16th December.
16th December. Returnable notice, returnable on him. Dusty mode is also permitted. Dusty service is also permitted. Interim pair will be considered on next date.
Item number 8.
May it please your lordship. Lordship, here in this civil revision petition, I have challenged the order dated 25/10/2024, passed by the learned civil judge junior division 3 of Kamrut, Guwahati. My lord, before coming to the, my lord, impugned order.
There was compromise between the plaintiff and the defendant.
Yes.
And you have filed a compromise petition also there.
Yes. We have physically appeared. We have submitted our agreement and also.
But when the compromise decree can be passed?
My lord?
When the compromise decree can be passed?
Because, my lord, we have compromised the suit by way of an agreement. The claims have been adjusted. But, my lord, we are going to pay 57,50,000, and out of that, we have already paid 25 lakhs to the plaintiff, and she agrees.
So the learned trial court in paragraph number 10 of the impugned order observed that there was no valid compromise entered into between the parties to the suit so as to adjust the claim of the plaintiff. Rather, the plaintiff would enter into the suit of a vendor if the compromise decree is passed.
Because my lord, the.
Is it permissible?
No, my lord, because my lord, the wrongly interpreted, my lord, the order 23, rule 3. My lord. That's why, my lord, she passed this, my lord, order. Because, my lord, order 23, if your lordship takes up, order 23, rule 3, there are two parts, my lord. Lordship got it? Where it is proved to the satisfaction of the court that a suit has been adjusted, here the word adjusted wholly or in part by any lawful agreement, compromise in writing and signed by the parties, or where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit. So first, my lord, may kindly see a suit has been adjusted. The word is used adjusted, wholly or in part, by any lawful agreement. Our agreement is a lawful one. Or compromise and signed by the party. And third part is where the defendant satisfies the plaintiff in respect of the whole or any part of the subject matter of the suit. So the trial court mixes all these.
Yes, Mr. You are appearing for other side?
I am appearing for a sole respondent, lordship. Yesterday I have filed Ukalatnama, lordship. This is a very simple case, lordship. A joint petition was filed before the learned court below for taking compromise decree, along with a compromise deed of agreement also. And court ought to allow the compromise, lordship. Because we are in joint petition, we stated everything, both the parties signed, and compromise deed of agreement also available. So court ought to pass compromise, lordship. When parties are agreed, then there is no issue, lordship.
Lordship, there is one judgment of Honorable Supreme Court.
On what point?
Followed on this, my lord,
The compromise.
when the court satisfies as to factum of compromise, court has to record same, no option to act otherwise. The parties have been, my lord, the issue was raised, my lord. Way back,
This is the relevant paragraph.
yes, the para 8 and 9. Para 8.
That is the submission.
My lord, relying upon several authorities of different high courts and one of the Privy Council referred to in the decision, the High Court held that once,
Where, Mr. Dotto, where is the ratio of the case?
my lord may kindly, I am reading from paragraph 8.
No,
Council,
no, may you show me the ratio?
my lord, then my lord may straightway go to paragraph 9.
Hmm.
We are in accord with the principle indicated in the said decision, which the learned advocate has referred. Said decision and are of the view that as the compromise petition is genuine and lawful, the same has to be acted upon. We direct that compromise petition shall be accepted and in terms thereof, the suit shall be disposed of and the terms of compromise shall form part of the order to be drawn up in this court for disposing of the special litigation. So in our case also, if the compromise decree is passed, keeping the compromise agreement a part of that decree, that much will suffice, my lord.
Heard Mr. M. Dotto, learned counsel for the petitioner, and Mr.
U.S. Borgovan.
learned counsel for the respondent. In this petition under Article 227 of the Constitution of India, read with Section 151 of the Code of Civil Procedure, the petitioner has challenged the correctness or otherwise of the order dated 25/10/2024 passed by the learned trial court in title suit number 231 of 2022. On a joint petition number 756 dated 29/6/2024. The learned counsel for the petitioner submits that the petitioner has instituted.
No, I have not received the one.
Who instituted?
Respondent, my lord. I am the defendant, my lord.
That the respondent herein as plaintiff instituted a title suit number 231 of 2022. What is the number?
Although initially it was, as my lord,
Page number 41, where the order above title suit number was written, 231. Page number 41.
initially it was 108/2016. Then it was 231/2020.
Title suit number 231 of 2022. Where is that plaint?
Okay, page lordship, 13.
13 onwards.
For specific performance of contract of the agreement dated 28/8/2013 and for permanent injunction and cost of the suit. In the said title suit, the petitioner herein as defendant file a written statement, and thereafter both the parties arrived at a settlement, and they have jointly filed a petition before the learned trial court under Order 23, Rule 3, read with Section 151 CPC for a compromise decree. Enclosing the agreement the parties have entered into. And thereafter hearing both the parties, the learned trial court by the impugn order dated 25/10/2024 has dismissed the petition on the ground that no valid compromise entered into by the parties to the suit so as to adjust the claim of the plaintiff, and the plaintiff would enter into the shoes of a vendor if the compromise decree is passed. The learned counsel for the petitioner further submits that the learned trial court has misinterpreted the provision of Order 23, Rule 3 of the CPC. And since the parties have settled the dispute amicably and entered into an agreement and prayed for a compromise decree, the court has no other option but to allow the same. And in support of his contention, Mr. Dotto has referred to a decision of Honorable Supreme Court in K. Venkata Session versus Kandaru Ramasubrama, within bracket date by LRS, reported in 1991, AIR SCW 808, wherein endorsing the view taken by Orissa High Court in the case of Bhajna Govindra Paikap versus Janaki Devi, reported in AIR 1980, Orissa 108. It has been held that once the court was satisfied that there was a compromise, it was for the court to record the same, and no option lay before the court to act otherwise. And that as the compromise petition is genuine and lawful, the same has to be acted upon. And as such, the impugned order so passed by the learned trial court is illegal and arbitrary, and therefore it is contended to set it aside. Mr. Gohai, learned counsel for the respondent, also submits that the parties have settled the dispute amicably and entered into an agreement. Is the date of agreement 28/8/2013 or different?
29/06/2024.
Where is that agreement?
35, page number 35.
On 28th June 2024, and thereafter
29.
29 June 2024, and thereafter
On the same day.
they have filed an application before the learned trial court. And as such, there is no impediment in passing the compromise decree between the parties, and therefore it is contented to no, and as such, he has no objection in the event of setting aside the impugn order and remanding the matter to the learned trial court. But having heard the submission of learned advocates of both the parties, I have carefully gone through the petition and the documents placed on record, and also perused the impugn order dated so and so, and also the relevant provision of law, that is Rule 23,
Order 20.
Order 23, Rule 3 of CPC, which reads under Section 3 of Title 1, with proviso and explanation. In the case in hand, it appears from the agreement dated 29 June 2024 that the parties have settled the dispute amongst themselves, and thereafter they have prepared an application before the learned trial court for passing a compromise decree. But in view of the submission of learned counsel for both the parties, and also considering the decision of Honorable Supreme Court in the case of K. Venkata Session, within brackets Supra, this court is of the considered opinion that the impugn order dated so and so passed by the learned trial court fails to withstand the legal scrutiny, and accordingly the same stands set aside and quash. The matter is remanded to the learned trial court with a direction to pass necessary order as per provision of Rule 3 to Order 23 of the Code of Civil Procedure, and also taking note of the ratio laid down by Honorable Supreme Court in the case of K. Venkata Session, within brackets Supra. The petitioner, the parties shall obtain a certified copy of this order and place the same before the learned trial court within a period of 1 week from today, and on receipt of the same, the learned trial court shall pass necessary order as indicated herein above.
My lord, the time frame kindly please.
Within 1 week, you produce the judgment before the court.
Item number 9. Obliged.
Please, Your Lordship. Well, my cross-examination was closed, my lord. In fact, my lord, and the matter has been fixed for argument, but I had submitted an application on that day, my lord, as unwell, my lord. I'd also submitted a medical prescription, my lord, because I had to visit the doctor that morning. My lord, I'm already suffering from some certain ailments, my lord, and the case is in Borpeta. I'm a resident of Guwahati.
And that's all right, but your conduct is not satisfactory.
My lord, he had to take some time on the earlier occasions also, my lord. And one of the last occasion was his father's Shraddha, my lord. That's why, my lord, he took time.
Yeah, all right, we will grant you permission to cross-examine the witness,
My lord.
but you have to pay some cost.
I understand, my lord.
And we will grant you only one opportunity.
Lordship.
If you fail to avail the same, then
True, my lord. Very fair.
heard Mr. M. Dotto, learned counsel for the petitioner. Order dated 30/10/2023, passed by the learned civil judge. Senior division or junior division?
Civil judge, senior division, Borpeta.
Civil judge senior division Borpeta in Manisut number 2 of 2021 is impugned in this petition under Article 227 of the Constitution of India. It is to be noted here that by order dated 30/10/2024, the learned trial court has closed the cross-examination of the defendant's witness number 1 and 2 and fix the matter for argument. When the next date is fixed?
The exit is fixed on 19/12/2024. It was fixed on 2011. It's been adjourned to 19/12.
On 28/11/2024. And
Now the next date is
2024.
19/12.
19?
12.
And subsequently, which is make it as submitted by Mr. Dotto, it is refixed on 19/12. 2024. Mr. Dotto, learned counsel for the petitioner, submits that the case was fixed on 30/10/2024 for cross-examination of DW1 and DW2. The petitioners herein, both are petitioner,
Yes, both are petitioner.
and on that day,
No, Malab, petitioner is one, only the plaintiff, Malab. Only the petition. Petition, the DW2 is wife, Malab. PW1 is the petitioner, the plaintiff, Malab. The
DW1 is petitioner.
DW1 is the petition, respondent. The defendant, rather.
That on 30/10/2024, the petitioner suffers from, which ailment he was suffering.
Well, I am suffering otherwise from that day I was unwell. I am suffering from several ailments like hypertension, fatty liver,
That on
and
that day,
hyperthyroid also.
on 30/10/2024, the petitioner was unwell and he has visited his doctor, and his wife, DW, who is DW2, also could not appear before the learned trial court on account of her busy with him. No, as he was busy with his treatment, and the learned trial court thereafter. Whether you have filed any petition there
Yes, madam.
on that day?
Yes, madam. Page 22.
And to that effect, one petition being petition number 1922
My lord.
of 2024 was filed before the learned trial court by their engaged counsel, but the same was dismissed and the case was fixed for argument. The learned counsel for the petitioner further submits that the petitioner may be given one chance for cross-examination of the DW1 and DW2, as on account of ailment he could not appear before the learned trial court on 30/10/2024, and to that, and in support of his submission, Mr. Dotto has also enclosed one medical document, one medical prescription issued by Dr. P.C. Das of Guwahati. Having heard the submission of learned counsel for both the parties, I have carefully gone to the petition and the documents placed on record. And also, here is the impugned order dated 30/10/2024. Okay. It appears that the case was pending on that day for cross-examination of DW1 and DW2. The petitioner herein shows sufficient reason for his failing to appear before the learned trial court on that day. On that day, and it is well settled that right to cross-examination of a witness, apart from being a natural right, is a statutory right. Section 137 of the Evidence Act provides for examination in chief and cross-examination and re-examination, and Section 138 of the Evidence Act confers a right on the adverse party to cross-examine a witness who had been examined in safe subject of course to expression of his desire to the same. And indisputably such an opportunity has to be granted. And considering this aspect and also considering the submission of learned counsel for the petitioner, this court is inclined to allow the petition. The impugn order dated 30/10/2024 is then set aside and quashed. The learned trial court is directed to afford only one opportunity to the petitioner for cross-examination of DW1 and DW2. However, the petitioner has to deposit a cost of ₹5,000 before the learned trial court on that day. In terms of above this CRP, I will sense dispose of at this motion stage itself.
Declare.
Item number 10.
Hello, Lordship, the cross-examination will be on next date or will some other date will be fixed with the court?
Next date.
Next date.
Please, Your Lordship.
Hmm.
So that in this case, the petitioner is the husband and the opposite party is the wife. The petitioner filed a divorce case in the year 2011. And therefore, the matter was placed before the councillor, and the councillor advised them to file an application for judicial separation. And accordingly, a application for judicial separation was filed, and order was passed at page 13, my lord. Terms and conditions.
No,
were given.
your only grievance is that the learned trial court
Yes,
has
delay.
fixed a long date.
Now, my lord, interesting, my lord, your lordship may be pleased to see, an application was filed at page 28. After 8 years, my lord, a divorce petition was again filed. Earlier, my lord, judicial separation was held 2016. Then in 2022, my lord, a divorce petition was separate, divorce petition was filed, and the matter was placed before the councillor. And the councillor, my lord, before the councillor, they both admitted that they have no objection in passing the divorce decree. Then councillor returned the file to the, my lord, principal judge. Principal judge, my lord, without passing or without going through the petition, my lord, he fixed the case for issues, evidence, etc. And the matter is delayed. Every 3 months dates are given, my lord. This case, my lord, the husband is fighting, or both the parties are fighting for last 13 years. At the age of 54, he filed this petition, my lord. Now he is 67 years. So, my lord, this petition is filed, my lord, that only this simple order is required to be passed, my lord. You will also be pleased to see the page 28.
No, now what is your pair in this petition?
My lord, a notice may be issued, my lord, and a direction may be given to the principal judge, my lord, family court, my lord, to dispose of the petition immediately, my lord. Preferably within 3 months, my lord. Because petition is there, both parties agreed, nothing is there, my lord, but the learned principal judge, my lord, delaying the matter by giving dates, evidence. Thereafter, after completion of the evidence of the petitioner side, my lord, again it will be fixed for defendant opposite party side. Then argument another 2-3 years, my lord. I have also filed prayer, my lord, before your lordship.
Where is that petition you have filed before the court?
That is at a page, my lord. At page 28. 29, my lord, that is the photocopy. I have the certified copy also. Both parties signed, my lord. That is in handwritten, that's why I have given this 28.
Okay, let notice go then. Let the other side appear, or
Only
Mr.
Next date is fixed on 6/1, my lord. Your lordship, if your lordship fix within 3 weeks, my lord, then the notice will come and your lordship can direct that on 6 itself the petition can be destroyed.
Heard Mr. P.K. Colita, learned senior counsel, assisted by Mr. Learned counsel for the petitioner. Order dated 28/6/2022, passed by the learned principal, Judge Family Court number 1. Is challenged in this petition. No. Order dated 5/10/2024. Passed by the learned principal, Judge Family Court in
Order sheet I have filed, my lord.
What is the number of the case?
800, my lord. Case number is 800.
Where you have mentioned it in your
FC civil case number 800/22.
no, in your petition, where you have mentioned it?
My lord, I am stating at page 7, my lord, para 13. That after attending the case for several days before the council, the petitioner and the respondent decided to file further settle the dispute amicably and accordingly on 19/7/23, a petition being petition number so and so filed by both the parties before AFC civil case number so and so. It is stated that the state petition, both the parties came to an understanding. The respondent has no objection against the divorce petition for passing an order of dissolution of marriage by decree of divorce.
In FC civil case number 800 of 2022. Is it the correct number?
Yes, madam.
800 of 2022.
800/22, madam. Order sheet also I have.
The learned counsel for the petitioner submits that the matter between the petitioner and the respondent was settled. And to that effect, they have filed a petition before the learned principal Judge Family Court on 19/7/2023.
That application before the councillor, madam.
Before the counselor.
Counselor, madam. Counselor.
Before the
Send the-
counselor, Principal Judge Family Court. Principal Judge Family Court number 1, Kamrup, Guwahati. And thereafter, the principal judge, thereafter the counselor has returned the file to the Principal Judge Family Court. Was there any endorsement of the counselor?
No, my lord, that orders are not supplied, my lord. Your lordship may be pleased to see page 31, order of the principal civil judge, my lord. 19/7/23, petition was filed on 19/7/23. On the same day, it was sent to the principal civil judge, my lord, for passing order. But he fixed the case for settlement of issues. At page 31.
And thereafter, the learned Principal Judge Family Court has fixed the matter for settlement of issues.
Yeah.
On 29/8/2023. Mr. Colita, learned counsel for the petitioner, further submits that the learned Principal Judge Family Court has thereafter fixed the matter on 6/1/2025 for evidence of PW license, between bracket license. And that since the matter has been settled between the parties, the learned Principal Judge Family Court, instead of taking evidence and thereafter to hear argument and to deliver judgment, please that question again. And since the matter has been settled between the parties, instead of taking evidence and hearing argument on that point, the court, the principal judge would have passed the compromise decree.
Yes.
Compromise decree. Would have passed the compromise decree, and instead of doing that, it has fixed the matter on 6/1/2025 for evidence of the witnesses. Under such circumstances, Mr. Colita, learned counsel for the petitioner, submits that at this instance, notice may be issued to the respondent, returnable in 3 weeks, and thereafter the court may pass necessary direction to the family court to pass final order on the petition. On the petition dated 19/7/2023. Let notice be issued to the respondent, returnable in 4 weeks or 3 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Justice service is also permitted. List the matter after 3 weeks.
Okay, date may kindly be fixed before vacation.
Correct.
18/12. May it please your lordship. Please your lordships, before proceedings, your lordship, the complete copy has not been served to me. I am a caveat in this case. No, 2 and 3, this page is missing in the main page. So they may be directed to furnish it to me. But tomorrow is date fixed, my lord.
Tomorrow, no, Friday, 29th.
Friday. No, your lordships, he has to furnish the proper copy, your lordships, and moreover, your lordships,
Tomorrow.
what right he has, is having, he is a judgment debtor in the, this suit, your honor.
The merit of the.
This suit is filed by the, this order 21/97/108 was filed by the, your lordship strangers. He is the judgment debtor in the title execution. I am the degree holder. And he want to adduce evidence in the third party petition, your lordship. What right he is having? All that he is exhausted in the suit. Up till the, your lordship, before your, in RSA, your lordship. What right he is having? Still, your lordship, let him furnish the copy, your lordship. If you want the copy, then let me furnish the copy, your lordship. There is no stay. Otherwise, my lord, the defaulter cannot be given your, because he is defaulted in giving the copy, your lordship. Let me some.
I'll have to see it.
So furnish a copy.
Now I'll furnish the copy.
Let the meter come either tomorrow or day after tomorrow. my lord.
Day after
Tomorrow, day after tomorrow, the case is fixed there, my lord.
When? Tomorrow?
I have no listening. Let tomorrow and day after tomorrow.
Okay, today, today we will issue notice then. Heard Mr. P.K. Colita, learned senior counsel assisted by Mr.
That's fine.
Learned counsel for the petitioner. And also heard Mr. Enenza, learned counsel for the respondent.
Number 5, your lordship.
Respondent number 5.
Degree holder.
Respondent number 5. In this petition under Article 227 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 19/10/2024 and 31/8/2024 passed by Civil Judge Junior Division number 2, Kamrup, Guwahati, in Miji case number 317 of 2013, arising out of title execution case number 3 of 2007. Let notice be issued,
Your lordships,
returnable tomorrow. However, no formal notice is required to be issued since Mr. Enenza. Is it not required to issue notice to other respondents?
other respondents are there, my lord. Your lordships, they are
They are
the
the
third party stranger. No, they have already filed suit, they have already examined, cross-examined and discharged. Now,
this judgment debtor want to give evidence in
Yes.
third party case. Where he already lose till of this number.
Well, the application is.
Where he is right.
Order 21, rule 97.
Only to install the
1957.
execution, your execution is pending since 2007, your lordship. He doesn't have any right.
The notice will be required to be served on the other parties, because they are the petitioners in the Mish case. They claim that they have right over the land. That is the order 21, rule 99 application. and
They
that
may
may be-
claim, but what is your right? Your right is already finished in the trial court, in the earlier round of
Yes,
proceedings.
I have a
You don't
right.
have any right.
I have a right, because I am a
You maybe
party.
made a party, but how can you say that you have any right in a third party case? And petition was filed by the third party directing me, against me only. And however, in this petition, your lordship, instead of saying that I am sitting in the digital land, the third party is saying that he is sitting in the government land. And by that way, your lordship, 2007, from 2007 till date, the execution was installed. And now the judgment debtor come and saying that I give the evidence. This is the case, your lordship.
These petitioners are necessary parties, my lord, because notices will have to record, will have to be served on the.
No, okay, we'll issue notice, but there will be no stay.
My lord, because order was passed on their application, my lord. Evidence was refused on their application, my lord. This
Then
is
how
opposite party.
you are aggrieved?
Yes, my lord, because I have to state.
Petition
whether
is
they are-
filed by the third party.
Yes, but I have to state before your lordship or the trial court by giving evidence, then whether these petitioners are carrying on business over the land or not. That is the important issue, madam. I may support the petitioners or I may not
Your
support.
lordship, behind the back, to frustrate the degree, now he going to adduce evidence saying that this stranger was sitting on the government, this greater land. This is the case, your lordship. Whether this can be allowed? It is the stranger who prove his case. He cannot be allowed to prove the stranger case.
At page
Only to frustrate
17,
the degree.
17, your lordship. may
This
be
is the
pleased to
motive,
see
your
the
lordship.
petition was
Altogether, this
filed
is the
by
motive. Nothing
some
else.
other parties, that is Vikas Chakraborty.
It doesn't have any locus, your lordship.
Notice is
No,
required to be served on
Mr.
them.
No. Mr. Kolita, you see, petition under order
21, your lordship.
Order 21, Rule 97 is filed by a third party. So how you are aggrieved?
Yes, my lord, because although the decree want to execute, my lord, this is a government land. What they want to execute decree over the government land, my lord. Their land is after the government land, my lord. That is the roadside land. I have to state these things before the court, my lord. Your lordship may be pleased to see that I have made opposite party number 2 in the Mish case, my lord, at page 17. I have enclosed the application.
No, but I could not understand that how you can adduce evidence in a petition filed by a third party, because your party is already over, decree is already passed.
The decree is already passed.
Then
Decree is already passed and third party file. Third party file application under order 21, rule 97, 99, etc. my lord. Where I was implemented as respondent number 2.
okay,
Respondent number
we'll fix the matter for maintainability of the petition. So not a to cut it. আগতে কি বলি বলো? 2013, arising out of execution case number 3 of 2007. Mr. Zah, learned counsel for the respondent number 5, submits that he has received copy, but the same is not complete. And therefore, Mr. Zah submits that the petitioner may be directed to furnish complete copy of the petition and the documents. Where is accordingly allowed, the counsel for the petitioner shall furnish the copy of the petition and the documents for Mr. Zah during the course of the day. list the matter day after tomorrow on the point of maintainability. To hear on the point of maintainability.
Much obliged.
This caveat 30 caveat would be heard. Caveat distance research. Okay, after we will resume.
Also did not appear. He is not in service since two thousand.
My lord, as per my instruction, telephone instruction from my lord, DE office Karimganj, my lord, the petitioner school has amalgamated with 1117 Ramdabad LP school. So therefore, my lord, I pay 1 or 2 days time so that I can bring the up-to-date instruction. My lord.
It is a matter of law, my lord. What has happened in this case? My lord, this respondent number 8, he is senior to the petitioner, while the school was in adventure stage. In 2012, his service was terminated, 2012 and 2013. And thereafter, my lord, but despite this, my lord, his service was provincialized. Respondent number 8 service was provincialized. We came before this court. This court set aside his order of provincialization, directed from consideration of provincialization of our service. The petitioner's service was accordingly provincialized. But against that single judge order, my lord, they went to appeal. And appeal, they said you try to directed the commissioner and secretary to find out whether the termination of respondent number 8 by the managing committee of the school is proper or not. So, managing committee of the school, my lord, accordingly, my lord, the commissioner has found out and has passed a speaking order saying that the school was provincialized in the year 2027-9-13 with effect from 1/1/13. This is the important crux, my lord. With effect from 1/1/13, but from his service was terminated in April 2013. So therefore, they are saying, so during the period of provincialization, the SMC doesn't have any power to do. So our contention is that we have communicated the order of provincialization only on 27/9/2013. So therefore, the order or action taken by the SMC, that managing committee of the school, you cannot touch it. Because this order will come into effect on the date of communication. And this order only gives benefit of provincialization of service in respect of the person whose service was provincialized. So there is a status quo order, and in view of that, the petitioner is continuing. And government of the last location has given a document which has been recorded by this court, saying that the petitioner, respondent number 8, is not in service since 2012. So therefore, the only consideration before the court is, my lord, the order of provincialization was passed on 27/9/2013 with effect from 1/1/13, whether the service which was terminated by the resolution of the managing committee in the year 2012 and subsequently on 27/4/2013 will have any effect. That is the only consideration. My submission is, my lord, that this order will come into effect from the date of communication only. And since prior to the order of communication, the SMC has taken a decision for terminating the service of the respondent number 8, it will not affect. At that period of time, the school was not provincialized. So this is my submission. I will give only one decision that the order comes into effect from the date of
No,
communication.
the other side, yes, Mr. Talukdar.
My lord,
They have given, they are in our favor only all this communication which they have given.
all right, my lord, but whatever, my lord, this school amalgamated with another school, my lord.
When?
So, that exactly I don't know, my lord. As per my lord, they amalgamated with 777 Ramadabad LP school, my lord. So, as per my petitioner, my lord, the earlier school, my lord, Amtolia school was provincialized, my lord. Whether this Ramadabad school is provincialized or not, so.
No, we are concerned with earlier school.
My lord, and my lord, another thing that, my lord, the petitioner did not attend the school, my lord. After amalgamation, my lord.
After?
Amalgamation, my lord, with this school, my lord. So lots of things. My lord, I came only, my lord, 2-3 days, my lord. In the meantime, my lord, I let him better come on Monday, my lord. Friday, I have some difficulties, my lord.
We have given additional evidence showing that in the amalgamated school, additional name is there.
In the amalgamated school.
Yes.
He has been
Page
walking
152.
now.
Yes, sir. Yes, he is working. As per the government record itself, government has submitted to the court. That your lordship will get it in page 157. That the
That was
petitioner is
in the
working.
year 1919, my lord. That instruction of
No, let them get
1919.
instruction, but
To get instruction, my lord.
fruitful instruction is already.
I pay only
before the court.
1-2 days. I think better come on Monday, my lord. I'm different.
2019 method.
19, madam.
Very short.
Short date.
It is at the instance of the government advocate, your lordship may kindly record.
Sorry.
Okay. Heard Mr. B. Didas, learned senior counsel assisted by Mr. B. Purkasto, learned counsel for the petitioner. And also heard Mr. B. Talukdar, learned counsel for the state respondents.
My lord.
Mr. Talukdar, principal granting him 1 or 2 days time so as to enable him to obtain up-to-date instruction. Here is allowed.
No, no.
Mr. Talukdar, last chance was given to you in the month of September.
2019, my lord.
No, 9/9/2024.
That reflected in order 25th September 2019 order 99 or in
Have you filed your affidavit?
no, my lord, because of my lord.
They have submitted only instruction, my lord. It is recorded in the order dated 9/9/2022.
If,
They have already submitted their instruction. It is recorded in the order dated 9/9/2022.
Okay, list the matter on. Okay.
4th December.
obligation.
13 for admission hearing.
Admission hearings. Record for the word.
13.
My lord, I am appearing for respondent number 3, my lord, for Board of Secondary Education, Assam, my lord. We have obtained instruction, my lord. As per report of the Inspector of School, Silsar, my lord, there are 8 numbers of students in class 9 and 25 numbers of students in class 9 enrolled in the school for the academic session 2023-24. Therefore, my lord, the board cannot withdraw the provisional recognition of the school, my lord. If they stop the enrollment of the student, the board can cancel the provisional recognition. Kindly peruse.
My lord, my case is not that, Lord. My case is that, my lord, the school was established on our parental property and amongst 2 brothers, 2 sisters. In persons to the order of the civil court, my lord, the property has been distributed equally among the brother sisters. One of the brother, my lord, he was a director, my lord, he want to grab, my lord, the private respondent number 5, my lord. So accordingly, my lord, we approached him, my lord. He forwarded the letter to the authority for cancellation of the recognition because it is not the property of the respondent number 5 alone, my lord. To that effect, my lord, a higher secondary has already been cancelled, my lord. Only education, high school part has remained, my lord. So it is the government, my lord, who has given the recognition, my lord. Lordship, kindly have a look at page 15, my lord, for a moment. It was given provisional, my lord. Provisional, my lord, it has given, my lord. After that of my parents, my lord, all the property has been mutated in the name jointly, my lord, in our 4 brother and sister. Thereafter, my lord, it did not work upon. Accordingly, my lord, we approached to the civil court, my lord. Accordingly, property has been partitioned. Now, my lord, Now, my lord, lordship will see all the brother and sister, page 42, has written letter to the director, who is the respondent number 5, at page 42. Thereafter, my lord, page 43 be seen, my lord, the director has referred the matter to the secondary education secretary, my lord, for the recognition of the school, my lord, page 43. And now, my lord, they have come with another plea. We have to stop. How we can stop, my lord? It is the benefit of the respondent number 5. He has already accepted the verdict of the civil court and property has been distributed. Distributed, my lord. Now, my lord, we other brother, sister, we cannot enjoy our property despite of having civil court's order. So for which, my lord, director he himself, the private respondent number 5, he is also one of my brother, my lord. He has forwarded his letter to the authority, my lord. Let him take a call on this letter, my lord, page 43. And what is the trouble on their part, my lord, to cancel the provisional recognition, my lord, election one? It was not given, my lord, finally. And how come, my lord, provisionally can be run for indefinite period?
For respondent number 5, my lord. Yeah, I'm for the respondent number 5, my lord. So, my lord, I have already written a letter at page 43, my lord. Since, my lord, apparently, my lord, I am also a part in the suit, my lord. So it was being compromised, my lord. And now, my lord, for the satisfaction of the decree, my lord, the share of the land has to be allotted to my brothers, my lord. But difficulty is that since the school is running, my lord. But even then, my lord, I have written a letter at page 43 to the director, my lord, for doing the provisional recognition that has been granted, my lord. So it's still pending before the authority, my lord.
What is the area of land being occupied by the two schools?
Schools, my lord, it is more than a bhiga, my lord. Lordship would see the mutation page starts from page 21 or 20, sorry, my lord. 20, my lord, there.
Where the state of Assam is a party here.
Yes, yes, yes. They have to make a call, my lord.
Who is appearing for state of Assam?
State of Assam, my
Respondent number
3, my lord.
3.
Board of Secondary Education, Assam. My lord, we may allow to file affidavit, my lord.
My lord, Lord Commissioner Secretary, Government of Education Department, my lord.
Who is for Education Department?
Name has been shown, my lord. Standing council is there, my lord. Now for this. Now, my lord. Respondent number 1 and 2 is, my lord. Name has been shown, my lord.
I see.
SC Education, SC Secondary, SC Education, SEBA. All name has been shown, my lord.
Well, what are the rule provides for the recognition?
Yes, my lord, for to start class 9 and class 10 permission, my lord, the school have to obtain the provisional recognition from the SEBA. That is why this is an essential criteria, my lord.
No, on what ground it can be recognized?
My lord, on the report submitted by the inspector of the schools, my lord, for the concerned school, my lord, that is on the basis of the report of my lord.
How come, my lord?
What report the inspector of school has submitted?
Yes, my lord.
What report the inspector of school has submitted?
Yes, my lord, regarding the land, my lord, infrastructure and numbers of students.
First and foremost, my lord, what I understand is that, my lord, suppose I want any recognition, land has to be there, my.
Yes.
But there is no land, my lord, because now it has been distributed by virtue of the civil courts order.
No, earlier there was land.
Earlier there was. Higher secondary has been cancelled. Only high school remain. Respondent number 1 and 2, my lord.
So, what would be the fate of those students who are being?
They will be accommodated nearby school, my. We'll assist them, my lord.
How?
We try to accommodate somewhere a nearby school. That will accommodate. This is a very few, my lord, 7 or 8, I think.
No. In class 9, 25 students are there, and in class 10, 8 students are there.
We'll try to accommodate, my lord, as far as assistance, whatever needed, we'll provide.
Okay, then let them file affidavit.
My lord, respondent number 1 has to file. What happened to that page 43, my lord? That is the vital issue, my lord. Secondary is, my lord, just a formal party, my lord. Recognition is not being given by the SEVA. Recognition is given by the Secondary Education Department. That's page 15. And for which, my lord, the then director or respondent number 5 has written a letter to the Secondary Education Department. What happened to that, man? Let him file, come with a clear instruction or to file affidavit basing on the page 43. SEPA, in this case, my lord, is merely a nodal office. Nodal. The role is played by the government.
Where is the permission?
Permission, lordship, will see page 15. Annexure 1.
This is granted by Board of Secondary Education.
My lord, lordship will see in pursuance to the decision of the board and fulfillment of the requirement condition of the institution concerned. The following high school madrasa is hereby accorded provisional recognition with effect from 94, with a permission to present the candidates to the high school living certificate examination as some high madrasa so and so.
So this was
It is
issued by
signed
the
by-
Board of Secondary Education.
It is signed by academic officer, Board of Secondary Education, Assam.
The respondent number 3.
Respondent number 3.
So let him file affidavit.
My lord, let him file affidavit, my lord. That is altogether no problem for him. My lord, what has happened onto the application dated page 43, my lord? No, multiple partition of it. Then 5 million. 1.5.
Over Director of Secondary Education. H. Tarang P. Is he available today? Available. Okay, at 2 p.m.
Item 14.
May I please your lordship? Lordship, the director of elementary education seeking 1 week time to complete the instruction, lordship. Respondent number 3.
Your lordship, last order make and leave it 8/11. All right, well, since 2021, my service was permissible. Now, no salary has been paid. That's why I approached before this honorable court filing and subsequently come with the impugn order that my provincial letter is rejected. And let them take instruction, my lord. Surprisingly, in the impugn order had no been mentioned, my lord. Why the reason? Reasonable. This is not a reasonable order, my lord. My lord, let them give a last chance, my lord, because otherwise your lordship order, my lord, 8/11, my lord, make and leave. Since 2020, in fact, the cause of action, my lord, of the non-payment of the salary is 2021. That is why, my lord, 3 years already lapsed. Yes, 1 week time, my lord, make and leave.
Heard Mr. A.K. Hussain, learned counsel for the petitioner, and Ms. S. Kaur, learned standing counsel for the education department. Or respondent number 1, 3, 5, and 6. Ms. Kaur, praise for granting her 1 more week time. One week time. There is allowed. It is made clear that no further time will be granted to Ms. Kaur. Please the matter on Kobe.
On
Fourth, man.
item 15.
Maybe for respondent lordship.
Who is for appellant?
Well, the council name is shown lordship, but has not appeared. The appeal has been listed for the first time lordship. Earlier there was delay lordship, delay condon.
Delay condon.
Appeal has been listed.
None appears for the appellant on call. List the matter after 1 week.
My name may be recorded lordship, for the respondent.
How about Mr. Hassan, learned counsel for the respondent, present?
After 1 week lordship.
Item 16.
Yes.
We have come against the order dated 2nd August 2019 passed in title 323 of 2012, lordship. This is an RFA. At this stage, lordship, the article may be admitted, lordship, and may be posted, and LCR may be called for, lordship.
Heard Miss?
Excluded, lordship.
Learned counsel for the appellant. This appeal under order 41, rule 1 and 2. Madam, you are appearing
I'm
for
respondent number 2.
respondent number 2. Madam, good name, please.
I'm Devi Lordship.
And Debbie, learned counsel for the respondent number 2. This appeal under order 41, rule 1 and 2, read with section 96 of the Code of Civil Procedure is directed against the judgment and decree dated 2/8/2019 passed by the learned civil judge number 2, Kamrup and Guwahati, in title suit number 323 of 2019. It is to be noted here that by the MP on judgment and decree dated so and so, the learned civil judge number 2, Kamrup and Guwahati, in title suit number 323 of 2012. affirm the judgment and decree dated where is the trial court judgment?
Lordship, it is at page 11, Lordship.
Follow line. No, not affirm, not affirm. Is dismiss the titles of number 323 of 2012. Peruse the memo of appeal and the grounds mentioned therein. Admit. Issue notice to the respondents returnable in 4 weeks that be taken by registered post with AD and also by usual process. 10 week from today. However, no formal notice is required to be issued since Ms. Devi learned counsel issued to the respondent number 2 since Ms. Devi learned counsel for the respondent number 2 appears and receive notice. However, extra requisite copy of the petition may be furnished to her during the course of the day. So, madam, are you representing this respondent number 1?
No.
No.
Only for respondent number 2.
MS Northeast Chemical Industries Private Limited is different entity.
No, Northeast Chemicals Industry, that is the appellant, Lordship.
They are representing Gupta High-Tech Industries.
What's it? Gupta High-Tech.
Yeah.
To the rest, however, step upon respondent number 1 be taken by registered post with AD and also by usual process with no from today.
I can appear for respondent number 1.
1.
Yeah, I see.
Okay, later on, Mr. Das, learned counsel, entered appearance for respondent number 1 and received notice. And as such, no formal notice is required to be issued to the respondents. However, extra requisite copy of the petition of the memo of appeal be furnished to the learned counsel for the respondent number 1 and 2 during the course of the day. Registrar shall call for the record from the learned trial court. List the matter after 4 weeks.
Obliged, Lordship.
Item 17.
Wait, please, Lord. But in this matter, my lord, higher education was to.
Lordship, here in this matter, Lordship, we have received our instruction today, Lordship. I need further 10 days time to file my affidavit, Lordship.
Mr. Das?
Date may be fixed in the second week of December, man.
Second week, okay.
11 or
Mr.
12.
Das, learned counsel for the petitioner, Mr. Upamanya.
Yes, Lordship.
Learned counsel for the respondent number
1 and 2, Lordship.
Respondent number 1 and 2. Mr. Upamanya submits that he has received instruction today and he will be filing affidavit in opposition and press for granting him 10 days time. Here is accordingly allowed. Registrar shall list the matter after 10 days. You are representing all the respondents.
No,
How many
for
respondents?
respondent number 3, my friend, Lordship, he is appearing. He Saliha.
And Mr. Soliha for respondent number 3.
Yes, Lord.
How many respondents are there?
Only 3, Lordship.
Only 3, okay. Are you interested to file affidavit?
Not yet, Lordship, because the regularization will have to be done by the
Department.
Yes, Lordship.
Okay.
Can it be on 15th December?
15th.
15.
Well,
Can be.
December
14, 15 is a holiday, Sunday.
Sunday, Lordship.
This is 25.
16, my lord.
16, okay.
16 December.
Item 18.
In this case, respondent number 3 and 4 are supposed to file affidavit. Respondent number 3 informed that he will file affidavit. Just now he has informed me.
Who is appearing for 3?
D. Mohanto.
Mr. Upamanyu, you were appearing for
One.
respondent number
1 and 2, Lordship.
1 and 2.
Lordship, for 4, my friend is appearing for 4.
4.
4, yes.
UGC.
Yes, Lordship. And Lordship, 5 has already filed an affidavit and they have filed their reply as well, Lordship.
Hmm.
College.
D. Monto was here. Kobe. D. Monto. So 1 week, then after 1 week.
And after 1 week, my date may be fixed. In the first week of this.
Heard Mr. Ensorma, learned counsel for the petitioner. And Mr. Upamanyu, learned counsel for the respondent number 1 and 2. And Mr. learned counsel for the respondent number 4. Whether Mr. Mohanto has filed affidavit or not?
Not yet filed.
He will file.
Yes.
When?
He informed that within 1 week he will file.
1 week.
Come after 2 weeks.
The learned counsel for the petitioner submits that respondent number 3 has not yet filed the affidavit in opposition.
4 also.
UGC. You will file affidavit.
Yes, sir. To take your instructions are when the instructions will be sent. Record permission is going to follow the permission. The PDB record permission.
Before, after 2 weeks, Lordship, I have received instruction, Lordship. Is
Later on, Mr. Mohanto appears.
I will file
Appeared and submits that he has received instruction and he will file affidavit in opposition for respondent number 3 and price for granting in 2 weeks time. Peer is accordingly allowed. Recessal is the matter after 2 weeks.
Date may be fixed.
Kobe?
8th January. 8th January. Item 19.
May I please, your lordship? Here, your lordship, service is complete. We have put to challenge selection of private respondent number 6, your lordship. And college authority has filed their affidavit, your lordship. They have denied our allegations, your lordship. But state has not filed their affidavit, your lordship. If your lordship comes to page 22, your lordship. That is the advertisement, your lordship.
22.
22, your lordship. Advertisement starts from page 22. Grade 3 and 4 different post, Bhavanipur College, your lordship. Then your lordship may kindly come to page 23, your lordship. Serial number 9, laboratory bearer, there are 4 posts, your lordship. We are concerned with schedule SC1, your lordship. Serial number 9, Roman 3, your lordship. Now, your lordship may kindly see educational qualification and the selection procedure will be as per Government Office Memorandum number so and so dated 24/1/2022 and so and so dated 28/7/22, your lordship. Now, your lordship, that office memorandum, your lordship will get at page 30, your lordship. Page 30, your lordship. This guideline for appointment of so-and-so provincialized gov model, grade 3 and grade 4 employees of provincialized gov model colleges at the of the state against valid sanction post. Then your lordship will kindly come to page 31.
No, Mr.
Lordship.
Thakur, whether all the parties are represented.
Lordship, it is served, but no one has represented for respondent number 5, your lordship, the private 6, your lordship. Others are your lordship representatives. But
Who is for respondent number 1 and 2?
higher education, your lordship. Their instruction probably will be necessary, your lordship.
So have you filed Take some time, they need to receive our instruction. Then why you are not submitting that some time will be granted to you? Why you are sitting there?
No, Lordship, since my senior meeting Lordship, that's why Lordship. Lordship, we need 2 weeks time, Lordship, to get our instruction, Lordship. College has 5 years. College, 3 and 5 has 5 Lordship. In fact, Your Lordship, I secured highest mark of 85, Your Lordship, and they selected a person, Your Lordship, who secured 36 marks, Your Lordship. That is the case, Your Lordship.
What is the criteria for selection?
Criteria, Your Lordship, the marks obtained in the HSLC examination, Your Lordship, and I have secured 86% of marks in HSLC, Your Lordship.
Third, Mr. S. Parthakur, learned counsel for the petitioner, and Mr. Upamanyu, learned counsel for the respondent number, standing counsel for the respondent number 1 and 2. And Mr. Sharma, you are?
3 and 5.
Respondent number 3 and 5. Respondent number 3 and 5. Mr. Upamanyu submits that he may be granted 2 weeks time to file affidavit in opposition. Here is allowed. Recessal is the matter after 2 weeks.
May I pray for a date, Your Lordship?
Kobe.
On 10th January.
Roughly, okay. Interim order shall continue.
Interim order is there. Till then, interim order pass earlier shall continue.
Obliged.
Item 38.
Obliged, Your Lordship.
Please, Lordship, for some personal issue, my senior is not able to be here. Kindly pass over for time being.
Okay, after some time.
39.
Please, Your Lordship.
Hmm.
Lordship may kindly pass over the matter for time being. My senior is on legs at force.
Who?
My senior is on legs.
Who is your senior?
He's on legs, Lordship.
Who is your senior?
Mr. M.U.
Mr.
Mahmood,
M.U. Mahmood.
Lordship. Lordship, yesterday heard this matter.
Yesterday?
Yes, Lordship. I was not ready yesterday, so Lordship, that matter. Your Lordship is about to remand back the matter to consider after
Yes.
cross-examination of circle officer, Lordship.
Yes.
And after going through the plaint, Lordship, I have seen that they have a different facts, Lordship. They are not disputing that there are any signature put by them in the Chita copy and all this. And on that ground alone, the learned trial court has rejected the plea. Your Lordship may consider after some time. If
Okay, next matter.
obliged.
For bail hearing item 20.
Here also the petitioner is in custody for 2 years, 3 months, 1 day as on today, Lordship. And sexual provisions of UAPA were invoked in the present case. And the other accused persons, most of them are on bail, Lordship. But granted by your Lordship. Second part. And trial court also they got bail, Lordship. The Impune FIR, your Lordship will find at page 26.
Whether he approached this court earlier?
That was withdrawn. Okay. Initially, one was rejected, then he again approached, but that
Where
was
is that a rejection order?
rejection order, your Lordship will find. Page 75, Lordship. Page 70 starts from page 75. There was a direction that after charges are framed, their bail will be considered. Sir, that order, your Lordship has passed various orders that are from page 95 onwards, Lordship.
So what was the allegation against him?
Against him, allegation was that they got training and thereafter lordship they were in association with one Saiful lordship. And
Which one?
With one Saiful. That your lordship will
Who is
find-
Saiful?
That specific allegations your lordship will find at page 66. And regarding other petitioner, page 67, second paragraph. And
No, present petitioner.
two petitioners lordship here. First,
paragraph 4, lordship, page
Page
66.
66, paragraph 4.
How many witnesses have been examined till date?
19 witnesses out of total 56 witnesses lordship.
90 witnesses.
19.
19.
Already examined.
And this is the second FIR lordship. That first case was sent to NIA lordship. But this present case was not sent to NIA lordship.
Is there any material against him in the?
Well, my lord, in the sense, my lord, only the seizure witnesses that some mobile and other things are seized from them, my lord. This is what the specific.
Except
Other-
is there any other material to show his complicity with the?
Till date, my lord, only the seizure witnesses are there. Till 19, my lord. 14, lordship may kindly see the PW 14. This says about this petitioner that some materials have been seized from him, my lord. In the later part of the scan copy, lord. The flag mark on PW 14, lord. Last part. Other materials witness yet to be examined.
Two 250 witnesses have been cited.
No, my lord, 56.
56.
Only 56.
Only 56. Out of that are 19 examined.
First, I'm giving that the list of dates when those witnesses were examined lordship.
Yeah. Let the trial is going on, my lord. Trial is going on at my lord pace, my lord. So, my lord, let the other witness be examined so that, my lord, no tampering and hampering of the witnesses will take in place, my lord.
But how long will it take?
Your lordship has
That is the
already
question, my
granted bail lordship in the month of January this year lordship. Considering that their period of detention, they are considering their period of detention lordship. And it was observed that it will take some more time lordship. Until that, they are only given 19.
Where is that order?
That your lordship will find at page 105 lordship. Paragraph 5 also nothing was referred regarding K. Najeeb's case. So, 4, paragraph 4, lordship, page 107. clarity your lordship has observed in another order, that is relevant paragraph page 120. Paragraph 11. 20. Paragraph 11, page 120.
Oh, but some other decisions are there prior to this decision. And those decisions were not taken into account in this decision.
That I leave up to you, lordship. But at the same time, lordship may already say that this is
The
the
earlier observation of the Supreme Court is that parity is not the law.
Parity is not the law, but at the same time, lordship, if they are on same footing, that can be considered, lordship.
No, their rule has to be taken into account
Lordship.
in commission of the
Lordship.
offense.
That is what I'm saying. The prime accused, that Mufti, he is the prime accused. He was granted bail, lordship. Mufti was the main person. He was granted bail. From Mufti, that Saiful Islam came. Then our name came.
Okay.
And just one thing, lordship, that this is the second that aspect also, lordship.
Pardon?
This is the third FIR, lordship. That first case was sent to NIA. Subsequently, he said that on the basis of when investigating the first case, he, lordship, got this news and subsequently lost the present.
No, is this present accused is in the case investigated by NIA?
Yes, he was there. And in fact, after perusing the materials on record, lordship, the period already under that sentence was awarded.
No, is there any proposition of law that once one case is handed over to NIA, the other case also has to be investigated by NIA?
No, but from the facts that has to be in the present case, he said, lordship, that I was investigating that case. But on the last occasion, I have submitted the charge sheet of the NIA case, which says that in the month of March itself, the case was transferred to NIA. He have no jurisdiction to investigate the issue, lordship. If any subsequent information is received, he has to pass it on to the NIA.
Information in respect of different offense, maybe in that case, he can continue.
No,
he can
it is
investigate.
not a different offense, lordship. That is why on last occasion also I have pointed out to your lordship that NIA order I have annexed here and the chart from the charge sheet. The allegations are exactly same, lordship.
Okay, we'll see.
Lordship.
I have flag mark, my lord, their witnesses, my lord. It trails against them, my lord, so far, my lord. Their role is that to recruit the my lord cadres and conduct meeting and also, my lord, in connection with the Bangladeshi outfit, my lord. That has come out from the.
Heard Mr. A. Ahmed, learned counsel for the accused, and Mr. Kusami, learned additional review for the state respondent. Argument concluded, order reserved.
Hello. May I mention urgent listing for RFA 59?
Is it the time to mention the matter?
I understand, my lord, but the matter is very, very urgent actually. That's why, my lord. Actually, the execution suit is in.
When do you want?
Pardon, ma'am?
When?
On Friday, my lord. My lord, is it on 3rd of December?
What
then-
matter?
My lord,
What matter?
it is a stay matter, my lord. Actually, the RFA has been already admitted by your by this court only. But then stay was given for stay was not granted that time because we are waiting for the opposite party to appear. But then yesterday the case came up, but the opposite party didn't appear, man. So in that case, my lord, and then they are appearing in the execution court and execution proceeding is going on. And then maybe because of this, they are ignoring this. Unless there will be a standing order from the court, my lord, we will not be able to stop the execution proceeding, my lord.
Friday, already a lot of matters have been
My
fixed.
lord, there is
Monday, then
I'm
Monday.
begging before you, my lord. There was no other option for me. at this
Monday,
moment.
next Monday.
Monday will be too late, my lord. Monday will be second and third is the.
When the next date is fixed in the execution
was
case?
the third,
Third?
3rd of December.
2nd of December it will be put up.
Second, I don't, if it is possible, my
No,
lord.
not possible because to Friday your matter may not reach. Already a lot of matters fixed. You confirm from the court master.
If it is possible, my lord, kindly.
No.
Pending item 13 for admission.
Please, your lordship, my sincere apologies, your lordship, I was not there at that time, your lordship. Lordship, here the prayer that has been made is to cancel the recognition of the school, your lordship. So lordship will give me some time, your lordship, because if your lordship sees the last annexure, your lordship, last annexure. Because affiliation has been discontinued, your lordship.
Affiliation in respect of higher secondary been cancelled.
For higher secondary, it has been cancelled, your lordship, and a recognition has to be cancelled by the director, I think, your lordship. So lordship will allow me some time to get the instructions. Lordship has to.
Director or the.
Because the school is a private school, your lordship.
No, that recognition was given by the Board of Secondary Education.
Lordship, that is why, your lordship, the board is still.
I thought we have accord provisional recognition to the school.
So how can the director de-recognize the school?
Lordship, director has no role, but then your lordship, sometimes it happens that recognition is also sometimes given by the director, your lordship. Let me get the instructions, your
May I
lordship.
pray one thing, my lord? Till, my lord, they filed their affidavit, my lord.
So
The
here we do not have-
operation of the provisional, my lord, that has to be stayed, my lord.
No.
Or, my lord, they have to give undertaking, my lord, no new fresher admission will be conducted, my lord. Because now session will start from March, my lord. Now they are taking, my lord.
No, on next that let them file affidavit.
My lord, if they take applications, my lord.
Before March, it has to be disposed of.
No, my lord, that, my lord, they will take applications, my lord. At least that part be restrained, my lord.
Lordship.
Remaining, my lord, 25 plus 8 will accommodate somewhere in nearby school. That undertaking I am giving your lordship. But for the new incumbents, my lord, at least they may be restrained, my lord, from taking any new application.
You file an IA then. We'll see. Barbhunya learned counsel for the petitioner and Ms. Musahari learned counsel
Fix
for
the matter on Monday, my lord. By this time I'll file my IA.
respondent number.
Lordship, respondent number 1 and 2, your lordship.
1 and 2 and
1, 2 and 4, your lordship.
1, 2 and 4 and Mr.
DK Roy, my lord.
DK Roy learned standing counsel for the Board of Secondary Education. Sheba, we can make it Sheba, and Mr. G. Alom for the respondent number 5. Ms. Musari, press for granting her some time to obtain necessary instruction. Peer is allowed.
We will also file our affidavit.
And list the matter after 1 week.
My lord, the date may be fixed, my lord. By this time we'll file our IA also.
9th December.
Prior to that, my lord, if possible.
On 4th December.
4th December.
4th of December. The meantime, the learned standing counsel for the respondent number 3 may also file affidavit in opposition if so advised.
Pending item 38.
Please, your lordship, my senior is on the way. Kindly pass over for some.
Who is your senior?
They have some medical issues on the way.
On the way. Yes. Okay, after some time.
Pending item.
Any other day, lordship, not today. Any other day.
On the way. For some time.
First of also, they take time for at 2. Any other day, lordship.
At what time he will be reaching court?
10 minutes.
10 minutes. Wait for some time.
Pending 39.
Let her submit, then I will reply.
Lordship, plain copy, annexure 1, page 13, Lordship. For going through the entire plain, Lordship, I found that there is an allegation that defendants. There was no whisper about Lordship recording of name in the chitta, Lordship. And thereafter, Lordship, we have filed our written statement, annexure 2, page 23. We have filed our written statement, your Lordship
No,
will find.
Madam, you say,
Lordship.
we are not testing the correctness or otherwise of the order.
Lordship.
We are simply remanding the matter to the trial court.
Lordship, my point is that, Lordship, after issuing notice in this case, the Lordship will find the order dated 1/12/2023. There is an order till the next returnable date. The further proceedings of title suit number 125/2021 pending before the Court of Learned Civil Judge Junior Division North Salmara Abhayapuri shall remain stayed, subject to condition that the petitioner shall produce a certified copy of the order before the learned trial court to bring the order to the notice of the said learned trial court. And thereafter, Lordship, in the month of February, they have filed amendment application before the learned trial court, Lordship. They want to bring on those facts on which they are seeking filing.
No, is this order against, no, is this petition against that order?
No, Lordship.
Then,
Lordship, I'm saying when the proceeding was stayed by this Honorable High Court, Lordship, thereafter amendment petition was filed by the petitioners before the learned trial court to amend their plaint, Lordship, and to bring the those facts in the plaint, Lordship. So they want to modify the pleadings, Lordship, and until.
no, that petition the trial court will consider in
Yes,
accordance
Lordship.
with law.
So, Lordship, until and unless those pleadings are brought on record by way of amendment in the plaint, if your Lordship allows their petition, or
Am I
Lordship,
saying
or
that I am
any-
allowing the petition?
no, Lordship, or
Then-
any direction passed by this court to consider the case of the petitioners, then it may, Lordship, hamper
No,
the.
that was the proposal yesterday I have given to Mr. Mahmood, and Mahmood also agreed.
Lordship. Lordship is remanding to take the cross-examination part of the circle officer only.
No, we are not concerned with the cross-examination of the circle officer. We are concerned with if anything come in the cross-examination of the, no, yeah, from the evidence of the circle officer that there is manipulation in the Siddha book, only then the court will consider the matter. Consider the sending of the this thumb impression with the Siddha book to the Forensic Science Laboratory for comparison.
Lordship, then their amendment petition will become infructuous as because their amendment petition is only to bring those facts.
Oh,
in
no,
the-
I am not concerned with the amendment petition.
Lordship may record that after conclusion of amendment petition.
No,
and-
why? Why should I record
That
it?
is a job of trial court.
But Lordship, that pleading has to be brought on record by way of
No,
amendment in the plaint. And if there is no amendment and circle officers after cross-examination of circle officer, the petitions are allowed. Lordship.
No, there will be no direction that the petition will be allowed by the trial court.
Lordship.
Trial court will consider it in accordance with
In
law.
accordance with law, and we may be allowed to participate by to file our written objection, Lordship.
Regarding?
That is automatic.
Regarding that, if any necessity arises, that.
No, why liberty is necessary?
Law provides that facility to.
Yes.
Lordship, then your Lordship in that aspect, if your Lordship wants to dispose it of, then Lordship may dispose it.
No, if you want to continue for years together, I have no problem.
No, Lordship, they will suffer it because they are plaintiff. And their suit has been stayed by this court. So if Lordship remanded back, I have no objection, but Lordship, only thing is that what was the prayer in both the petitions, those were not within the pleadings, Lordship, in the plaints. That was categorically stated by the learned trial court in page 52, your Lordship. that there is no single averment in the plain to the effect that the defendant number one or any of the other defendants got their names mutated, recorded in the revenue records in respect of the suit length by forging thumb impression of the plaintiff in the chita. That is second paragraph, Lordship. To the contrary, the crux of the case of the plaintiff is that the defendant numbers 1 and 2 entered into the suit length as permissive possessors. And they illegally transferred the suit lengths to the other defendants by execution of registered gift deeds. Thus, any evidence pertaining to existence or non-existence of thumb impression of the plaintiff in the relevant chita of suit length would be beyond pleadings, and it would not be proper for this court to allow any such evidence to be brought on record at this stage. Further, such evidence shall also cause severe prejudice to the defendant. So after this findings, Lordship, they file amendment application. As there was no pleading about, Lordship, this chita book, Lordship.
That's why if in the evidence of the circle officer NSS facts common record, then the court will consider it.
Lordship, if your Lordship.
If no such materials comes in the evidence of the circle officer, the court will not consider it. That is the proposal I have given to him. Mr. Mahmood also agreed.
Lordship. Even if anything comes out from the cross-examination of the circle officer,
No,
Lordship.
we will not give any detailed direction.
Lordship.
We'll leave it to the discretion of the court, trial court.
Then
Heard Mr. Mahmood, learned counsel for the petitioner, and also heard Ms. R. Sodori, learned counsel for the respondent. In this petition under Article 227, read with Section 151 of the Code of Civil Procedure. The petitioner has put to challenge the correctness or otherwise of the order dated 25/8/2023, passed by the learned civil judge, Junior Division North Salmara in Abhayapuri, entitled suit number 125 of 2021. It is to be noted here that by impugned order dated 25/8/2023, the learned trial court has dismissed the petition. Petition number 2918 of 2019 and 2919 of 2019, filed by the petitioner for sending the thumb impression of the petitioner and the Siddha book to the FSL for comparison and opinion. Mr. Mahmood, learned counsel for the petitioner, submits that the name of the respondent herein entered into the Siddha book. In respect of the suit length.
Number 1 and 2.
Respondent number 1 and 2, and on the basis of the said entry in the Siddha book, they have claimed their right, title, and interest over the suit length. Mr. Mahmood submits that the petitioners herein never put their signature or put their thumb impression in the Siddha book, and the same is obtained fraudulently. And as such, there is a requirement of sending the said Siddha book containing the thumb impression of the petitioners, and also their admitted thumb impression to the FSL for comparison and obtaining opinion which will definitely help the court in arriving at a just decision of the case. And therefore, Mr. Mahmood submits that the impugned order suffers from illegality and requires interference of this court, and it is contended to allow the petition. On the other hand, Ms. Soduri, learned counsel for the respondent, has submits that there is no averment in the pleading of the petitioners in respect of the thumb impression in the Siddha book. And as such, the learned trial court has not committed any illegality or infirmity in dismissing the petition filed by the petitioner. But it is also to be noted here that the petitioners herein has filed another petition number 2914 of 2019 for summoning circle officer as witness. And the learned trial court has allowed the said petition. Whether circle officer is examined or not?
Not yet.
examined.
Not yet.
examined.
Sejongam Circle Officer.
Circle officer of Sijangram. Mr. Mahmood, learned counsel for the petitioner, submits that the circle officer, though the learned trial court has allowed examination of the circle officer, he is yet to be examined. In view of above, it is provided that if NSS materials in respect of fraudulent entry in the Siddha book comes in the evidence of circle officer, then the learned trial court shall consider if there is any requirement of sending the Siddha book and the thumb impression of the petitioner to the FSL for comparison and opinion, and thereafter pass necessary order in this regard. In terms of above, this CRP IO stands dispose of at this stage.
Lordship shall consider in accordance with law.
In
Lordship,
accordance with law.
Implied.
if necessary.
That is implied. Court functions are always legal.
May I pray to, without being influenced by any.
Sorry, no such observation will.
No,
I've not made any observation in favor of him or you.
Lordship. Obliged.
Items for hearing under order 41 Rule 2 CPC. Item 21.
My lord, on the other day, your lordship had directed me to present before your lordship that.
You obtain it.
It was, yes. My lord, Halucha Engineering Limited is the respondent, my lord. And on 2/4/2016, my lord, by this common letter, there are many creditors to that company, my lord. So at serial number 1, your lordship will be pleased to see GD Motors. In the name of GD Motors, rupees 3 lakhs. My lord. This letter was written by the company to the manager, branch manager, State Bank of India, Jairampur branch, to dispatch this much amount, 15,85,750 to the various their creditors, my lord. serial number 1 is GD Motors. Who is before your lordship? That was the common check issued, my lord, for all the persons. That is 15,85,750. And the total, your lordship will be pleased to see at page number 1 itself, the total of 15,85,750. Out of that, I am entitled to get only rupees 3 lakhs, and it has come to now.
This check was issued by whom?
By Bhalucha, my lord, Bhalucha Engineering Limited. The check was issued to State Bank of India, my lord, giving the statement details that whom to be paid, how much amount. That is page number 1. And my lord, serial number 1 speaks about me, GD Motors, 3 lakhs.
Why this common check?
My lord, they don't. That may be the arrangement, my lord, maybe between the bank and that of the company. Rather, by this letter, my lord, they want to disburse that liability to this tune, my lord.
So your contention is that last you have deposited a sum of rupees 3 lakhs.
3 lakhs on 2/4/2016, my lord.
Two 2014 or 16?
2014, my lord, account was continuing, and
no, in your no, in your petition, at which part you have mentioned the matter?
my lord, I have mentioned at page number 28, my lord.
20?
My lord, that's my plain. Page number 28, my lord, in paragraph number 3, my lord.
No, in your petition before this court.
Regarding the mentioning of the amount, my lord.
Yes.
That, my lord, it is my lord in this substantial question of law itself, my lord. And that I have mentioned in my paragraph number 3 at page number 28 of the plaint, my lord. The other day, my lord, I had shown your lordship page number 28 of the plaint, which is my petition, my lord, I mean the plaint. My lord, paragraph number 3. Yes, my lord, may I read that part, my lord? During the financial year 2016, paragraph number 3, my lord, just 10 lines below. During the financial year 2016-17, the plaintiff supplied materials to the defendants amounting to rupees 2,66,695 on credit. During the said financial year, the defendant paid rupees 3 lakhs on 2/4/2016.
I will see. What's the order? Not now. Examine the matter.
Only one substantial question I had read.
Only one.
Only one. Ulai.
22. Please, Your Lordship. The appeal is been preferred, Your Lordship, against the concurrent finding of the trial court and the first appellate court, Your Lordship. The gist of the matter is, Your Lordship, the plaintiff and the defendants, they are brothers and sisters. And after the death of the father, there was a land, Your Lordship, one katha, 14 lessas, Your Lordship. And the said land was ought to have been divided equally between the brothers and sisters. The sisters, they have relinquished their right, Your Lordship. But they have left over, and the brothers, the two brothers were left in this case, Your Lordship. The defendant number 2, he is in possession of the suit land at present. And while going for the mutation, Your Lordship, they had objected to it, and the plaintiff has filed the suit, which was decreed, dismissed, Your Lordship. Thereafter, the appeal has been preferred, and there was also a dismissal in the appeal. Your Lordship, may kindly peruse page number 38, Your Lordship. The suit was dismissed only based on an exhibit ungo, Your Lordship, which is an affidavit drawn by all the brothers and sisters.
Page number 30?
38 of my appeal memo, Your Lordship.
38 is a part of the judgment.
Part of the judgment, Your Lordship. Internal page 13.
Yes.
Paragraph 31. It is proved from the material on record that the plaintiff and defendant numbers 2, 3, 4, and 5 sworn an affidavit, that is exhibit ungo, before the notary public, declaring and tendering no objection that the suit property may be mutated in the name of the mother of the appellant plaintiff. Although the appellant plaintiff has denied of any family settlement, yet as he executed the exhibit ungo, and as all the family members, including of him, have put their signature on exhibit ungo, it can be presumed that a family settlement is agreed upon by all the family members of appellant plaintiff and the respondent defendants. Only based on the presumption, Your Lordship, the suit was dismissed. The question here is, Your Lordship, can a right can be relinquished by way of affidavit, Your Lordship, without a registered deed?
Without
a registered deed, Your Lordship, of relinquishment. Only based on this presumption, Your Lordship, the suit was dismissed.
So exhibit ungo is the
Affidavit,
date,
Your Lordship.
affidavit.
Affidavit.
Okay, heard Mr.
H. Buravan, Lordship.
Learned counsel for the appellant. This appeal under section 100 of the Code of Civil Procedure is directed against the judgment and decree dated 29 judgment dated 29/9/2018 and the decree dated 6/10/2018 passed in title appeal number 4 of 2016 by the learned additional district judge number 2 FTC Tinsukia hereinafter first appellate court in affirming the judgment and decree of dismissal passed in title suit within bracket partition number 18 of 2010 by the learned civil judge Tinsukia. Here's the memo of appeal and the grounds mentioned therein, and also the impugned judgment and decree dated so and so, so and so. This appeal is admitted on the following substantial question of law. Whether the trial court judgment is at page number
Trial court judgment is at page number 6 of my memo of appeal, Your Lordship.
whether the learned courts below are justified in dismissing the suit of the plaintiff on the basis of an affidavit unregistered on the basis of an affidavit. No, is there any provision for registration of an affidavit?
No, Lordship, there should be a deed of registration, Your Lordship. It is only as affidavit, notarized affidavit, Your Lordship.
On the basis of exhibit ungo, a notarized affidavit dated 29/10/2017.
7, Your Lordship.
7 or 17?
7, Your Lordship, it is wrongly typed.
2007. Let's start going. The court may also consider framing of any other substantial question of law if found necessary at the time of hearing. Issue notice to the respondent returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Rest will call for the record from the learned courts below is the matter for 4 weeks.
Deeply obliged.
Pending item 38. 38.
Lordship, first of all, I want to apologize, Lordship. I wasn't tracking some suggested. Lordship. So here in this case, Lordship, so the school has provincialized, Lordship. So due to the non-availability of the dice code, the school has withdrawn my provincialized, Lordship. So here, Lordship, the annexure 18, Lordship, annexure 2, Lordship, page number 18, Lordship. This will have defined, Lordship.
Page number?
18, Lordship. Kindly find lordship.
Mm.
So here lordship, the data capture format, district information system of education dashboard, academic year in the year of 2009 and 10 lordship. So there, academic year is available lordship by the concerned department. And lordship, the respondent number 5 is a BO lordship, himself state lordship, is a page number 37 lordship. And find that. And page number 36, the director himself issued a letter to submission of proposal report in respect of the dice code lordship. And thereafter, lordship, the BO has reported the submit lordship, the page number 37 and except 6 lordship. Lordship, kindly find lordship. So here lordship clearly defined, may I read lordship. With reference to the subject cited above, I have the honor to request you that the newly provincialized Rajiv Gandhi LP School dice code is having from the academic session 2009-10, 2010-11, 2011-12, 2012-13, and 2013-14 lordship. So the dice code report is available lordship as per the respondent number 5 lordship. And lordship, the respondent number 7 lordship, the file affidavit and opposition lordship. So annexer A lordship and define lordship.
Annexer
A lordship.
Page number?
Page number 61 lordship. Lordship, here lordship, there we say the middle part lordship. The school has provincialized lordship in the year 2013-14, newly provincialized. And lordship, lordship kindly find lordship. 2013-14 initially stage provincialized and up to 2016-17 lordship. 2016-17. The middle part lordship. So lordship, so the petitioner school was withdrawn lordship by the director. Annexer 4 lordship in my lead petition lordship. Now can you find lordship? Page 35 in my lead petition lordship.
So from 13-14
yes,
to 16-17 it was provincialized.
Yes, lordship.
And thereafter
lordship,
de-recognized.
Yes, lordship. Thereafter the and lordship, in this document lordship, some discrepancy lordship. The page number 35 in my lead petition lordship can define lordship. Page number 35 annexer 4 lordship. So here lordship, the director himself state lordship. Can define lordship. Page number 35. The order dated so so the provincialized order issued by this office order memo so and so dated 13/5/2013 in respect of Rajiv Gandhi LP School is hereby withdrawn due to the non-availability of the dice code as per the office record lordship. So here lordship, the apparently discrepancy lordship. So 2000 is a 2014 lordship, the 1st February 2014 lordship. The school has withdrawn the provincialized due to the non-availability of the dice code lordship. So here, documents lordship annexer A and the affidavit filed by the respondent number
So
7.
this page number 18, annexer 2. So this is the dice code of the school.
Yes, lordship.
It was in the year 2009.
9-10 lordship. And the issuing order says lordship is a.
Thereafter, what happened?
So thereafter lordship.
No, how the dice code disappeared after this 16-17?
Lordship, the annexer BO lordship, which is clearly defined annexer 6, the page 37 lordship. So up to 2013-14 is a academic record is available lordship.
Annexer?
Annexer 6 lordship, page 37. And dice code number is a 1811-020-53505 lordship. The respondent number 5. Block Limited Education Officer himself state lordship. And lordship, the issuing order says lordship, the page number 42, which I have challenged lordship. Annexer 8 lordship. So last part lordship, the operative part. Where is kindly find lordship? Where is as per the government Assam's notification height, letter nang sonso dated sonso dice code cannot be allotted for the year that already elapsed. And it has been circumvented that the dice code number sonso cannot be included in the year 2019 lawsuit. So that documents reflected lawsuit. The 2019 is a recorded lawsuit dice code. So here speaking order says lawsuit the elapse of the 2019 lawsuit dice code record. So there's some discrepancy lawsuit. And the lawsuit
No, this the dice code mentioned in this speaking order
yes, lawsuit.
is 181110205305.
05 lawsuit.
And the code school code mentioned is different in 2009 for the academic year 2009 and 10.
Lordship, the initial part is a missing lordship, and last part is the same lordship.
Last part is same.
Yes, lordship. And lordship, annexer 6 is also clear defined lordship. The BO himself is still lordship. Annexer 6 is the last part lordship or party part.
Annexer?
Annexer 6 lordship.
Yes.
So is Rajiv Gandhi LP School, so dice code of school 18110205305305. This is the same lordship. Along with this speaking order lordship.
Last 6 digits are same.
Yes, lordship. And annexer 8, page number 42, and annexer 6 lordship are same dice code lordship. So here lordship, the annexer 2 is a page number 18. So initial 5 digit has been missing lordship. The school code lordship. And the page number 20 lordship is the same lordship dice code. Data capture format lordship. Which is reference dated 30 September 2012 lordship. 181102205305 lordship. Lordship, where is lordship the section 3 of this act lordship?
Who is appearing for this SSA? Mr. Gogoi. So this dice code is available since the year 2009.
But my lord, as per the record available in NIPA, lordship will find that page number 61 of our affidavit. Page 61. It is available only from 10-11. And my lord, even in 10-11, the name of the petitioner does not figure. At the top. 9-10 is not available.
Then this page number 37, this annexer 6. This is the letter of Block Elementary Education Officer.
Yes, Lord.
There it is mentioned that since the academic year 2009-10 up to 13 and 14, it is there.
No, we will see the impugn order at page 42, the second paragraph. It says, my lord, whereas as per record available at national level submitted by the states and uploaded at so and so by National Institute of Educational Planning and Administration, NIPA, New Delhi, under so and so. Dice code number, this is the dice code of the petitioner, is available from the year 2010 and 11. Dice data is submitted to national level every year after final compilation at district level. No school can be added after final submission. So here is the problem. Even if some report is submitted now, we cannot correct it. Lordship, the petitioner will have to implement this NIPA.
No, who is responsible for uploading the data in that website?
That website, my lord, after every year, my lord, it gets, my lord, that portal is closed. Thereafter, we cannot add, my lord, 9-10 now. It will have to be uploaded at that point of time.
No, yeah, it was already there. for some, it was not updated in the website.
No, there is no dispute regarding that. What the impugn order says, after every year the final compilation says no school can be added after the final.
No, that's all right.
submission. That's the
We
issue.
are not
Otherwise,
concerned with that.
yes.
We are not concerned with that. We are concerned with this letter. This
The education department says, Melody, if it is there, then it is there.
So this is
Page
this
37.
37.
Yes. If on verification, this letter has been issued 13/2014, and nobody is disputing it, then of course, my lord, because of some technical flaw, if it is not there in the website, petitioner, otherwise, my lord, if as per the rule, provisional rule, if the petitioner is entitled, that cannot be deprived. That, my lord, issue is clear.
So
but, my lord, in order
no,
to-
my question is, can we ignore this letter?
No,
Yes,
of course not, my
37.
lord. Of course not, but what has happened is, my lord, now we cannot, my lord, incorporate it in the, that is the, my lord, difficulty in the, my lord, web portal. So
Who is
NIPA, if it is made a party,
who
then it is-
upload the data there
but
in the
from
website?
state level, it is the education department who is to do that.
So why for the fault of education department he will suffer?
Yes, in fact, my lord, orders have been passed in similar cases. But, my lord, even then, my lord, we are unable to upload it because of this difficulty in the, my lord, portal itself. That we cannot edit after a particular, my lord, period. The window gets closed. In fact, my lord, we had to face contempt also, my lord, in some cases. But we are helpless, my lord. This NIPA authorities, my lord, they are, the authority will have to upload it. My lord, again, tomorrow the petitioner will, again, my lord, they will face problem. Because the data will have to be there. It is a data which is, my lord, maintained for the entire country in various portals. So, my lord, NIPA is
No,
my lord,
you come to this Annexure 2, page number 18 also.
Lordship.
There also it is mentioned. It
Yeah,
was
it's-
dated 30th September 2009.
No, I've gone through it, my lord. It is there because that's why, my lord, they have given the report that it was there from 9 itself. And 9 is only, my lord, 9 and 10 is required, my lord, for getting the provincialization. Minimum, my lord. If some, my lord, the instruction, the education can furnish on this point.
After 1 week, Lordship.
Pardon?
After 1 week, Lordship.
After 1 week.
In fact, my lord, on technical ground, the speaking order has been passed, not on merit. Lordship will see the order, he says that it cannot now correct it. That is the speaking order. Nobody says that, my lord, petitioner is not entitled. The order which is on the challenge page 42.
No, what was the order of this court?
To consider the representation as to why it is not there. So we have submitted that in the portal, it's not there. And now, my lord, even
That's
if
all
it-
right, but can it be said that it is a speaking order?
yes, it's a speaking order.
No. This order has not taken note of this letters, Annexure 6, Annexure 2.
No. We have only verified the web portal. There is SSA's role is limited to that only, madam. We can check the portal.
Was the direction of this court that
Yes, my lord, the page 41, lordship will see. Because no such mandamus was issued, my lord, that he should be given or not. So they will submit a representation, we'll verify. On verification, that's why we said, my lord, we have not said that they are not entitled. We said that, my lord, the portal is closed, now no school can be added after the final submission. That is our otherwise, my lord, purport of this particular speaking order.
This is the tone of the authority, Lordship. The record clear defined, Lordship.
No, there was direction to file fresh representation. And thereafter, the respondent 7 to consider the same.
38, my lord, page 38 of the
38, Lordship.
representation.
Mission director shall examine the matter and dispose of the same in expeditiously, as
Okay.
expeditiously as possible.
So representative submit.
No, one thing, my lord, if the education department confirms that page 37, my lord, is valid, that is the record, my lord, which they have. that case lordship can pass an order. On that basis, they will get the benefit. Even though it is not there in the portal, we
No,
cannot change it.
my point is, there is direction to consider the representation.
If that speaking order is passed,
Definitely, representation is accompanied by these annexers. Where
Page-
the
page
mission
30.
director has considered these documents.
Yes, boss.
Hmm?
Page 38.
Can it be said that it is in speaking order? Why the other documents he had not considered?
No,
He had
well,
not
even
brought
no,
before
well,
this
what-
court the actual picture.
No, we are to consider whether that particular dice data of 9 and 10 is there or not. That we have considered. Even though the petitioner submits.
That cannot be said to be speaking order passed by a director.
But finally the outcome will be same. We cannot say that he can be provincialized because the data is not available. Right? If Honorable Court, after verifying everything, says that yes, even though that is not there, since the record speaks clearly that on 9 and 10 there was a dice data and not been disputed.
Mr. Gogoi, you see, in which part of this speaking order the director has considered the other documents enclosed with the representation? Is there any reference?
No, my lord, I'm not on that. Even though
No,
if we
but
consider
you-
it, because
you
in the
got my
affidavit
point?
Yes, I understand, my lord.
Oh.
But my outcome will be same. That's what I'm saying.
No,
my lord.
whatever be the outcome, where you have considered it?
Because we can only consider the dice data. Being a Sarva Shiksha Abhijan, we can only consider that part. The
No,
provincialization is
that
entirely
is
of the.
that is not the speaking order, Mr. Gogoi.
Yes, boss.
Mr. Das, can you show what are the documents you have enclosed with that representation?
And the page 38 says, my lord, the Honorable Court's order has been submitted along with a copy of the writ petition and filed at that point of time, along with all the annexes. Probably these
Then-
documents were, of
then,
course, will be a
then-
part of it.
If the annexers were part of the representation, then where you have considered those those annexers in the MP in the order, speaking order?
Yes, sir.
So this is not the way of handling the matter, Mr. Gogoi.
No,
You
if
tell
you
your
also want
director.
to, my lord, refer it back, we can consider, but my lord, ultimately it will be
No,
unnecessary.
that is a different
delay.
matter, but you have not considered it.
So even though my lord, it is there, we cannot, because also will see affidavit also. We have not made any single comment on this particular annexes. Same annexes has been mentioned here. We are
No, you
disputing
ought
that.
to have made comment on that annexers.
My lord, we cannot because those are not our record. SSA can only see, my lord, in the web portal. Even in the affidavit we have stated.
No, is it not your duty to verify the same?
No, even if, my lord, it is verified also, my lord, we cannot go beyond that because lordship will see provincialization order was
That's
issued
all right,
thereafter
but
can-
you could have stated the true facts in your affidavit.
Yes, lordship, exactly. No, we have not disputed it, my lord. Moment
No,
we
no,
have not
no,
disputed it, we have
disputing or
admitted it.
not disputing, these are different matters, but
Yeah.
this is not an speaking order. Let the director remain present in the court then.
Yes, unnecessary, my lord.
Not
ultimately-
unnecessary. Why unnecessary? Necessary or unnecessary will be determined by the court. Who are
No,
you
I'm not
to
on
tell
that-
it?
No, I'm not on that point. But my lord, even then, my lord.
Mr. Gogoi, this speaking order is a contempt of this court.
my lord,
I'm telling you.
Contempt will come when, my lord, there is a willful violation of honorable
Yes.
court order. The order has been passed, my lord.
Yes,
The contempt will come, my lord, when, my lord, it has not been
you have
complied.
not considered the relevant documents.
My lordship will say the honorable court order where it is mentioned that, my lord, they will submit annexes, it will have to be considered, my lord. Let us.
Here, there is this representation is there.
Yes, yes. That part we have considered. My lord, even if, my lord, that's why I'm saying, my lord, I'm not on, my lord, anything, my lord, against the petitioner. Neither something is there in an affidavit stating that they are not entitled. We can go, my lord, cannot go beyond our limit. That's what I'm saying, my lord. Being a mission
Let the
director.
director come. Okay.
My lord, today, even if he comes, my lord, this is the order. We have filed our affidavit. Lordship will decide on that.
We'll ask him why he did not consider the other other
Have
document.
a written instruction whether, my lord, this, as per this particular representation, whether those documents are actually furnished or not, we will submit an instruction, my lord. Lordship will grant me at least 3 days time. But what I am saying is, my lord, Lordship will give a relief to the petitioner. On that basis, they will get, because they have
No,
orders
no,
passed.
that is a different matter. If the relief could have been granted in that stage, why the petitioner is?
We cannot, my lord, we cannot go beyond. That's why I am saying, my lord, I am not against anybody, my lord. There is not a single statement that petitioner is not entitled. We have only relied upon the data. Being a Sarva Shiksha Abhiyan mission, my lord, we cannot go beyond the data. And we have stated now we cannot correct it. The portal is closed. And it is a central agency who is to keep them, those data. It is not the state, under the state government, my lord. We have given the web portal, we have stated that even today also, if they check.
That's all right, but this is not a speaking order.
But then, my lord, this is not challenge. Lordship can interfere with that. Giving us, reverting back it to us to consider it, my lord, as per the consider.
No, the thing is that you have compelled him to running from pillar to post, in spite of availability of the data.
My lord, one thing, my lord, may I clarify, my lord, whatever losses passes, my lord. On this point, I can have a clarification, whether we have the power to say that, my lord, whether he will be provincialized or not. Even though these particular documents are there. Because there is not a single whisper in an affidavit also, my lord, even though today also those documents are there in the writ petition. We have submitted a, my lord, affidavit of position replying to everything. We have not said, my lord, this particular document at page 37 cannot be relied upon. We are bound, my lord, we are limited to our, my lord, own jurisdiction. We cannot go beyond that, my lord. We are not the authority to decide whether they will get the provincialization or not, my lord. It is the 2000, my lord, these 17 rules. It speaks very clearly, my lord. Act and the rules. It is the education department who will, my lord, state level committee, district level committee, they will consider, my lord. Since, my lord,
I am not on that. I am on this speaking order. Where you have considered the relevant annexers.
If that lordship will pose a query, definitely I will place, my lord. I will place the written instruction, my lord. What I am saying is, my lord, only thing is that, my lord, even though these documents are there, whether we can pass an order stating that he is entitled for provincialization.
Oh, I am not concerned with that. Where you have considered the documents? You saw from the speaking order?
Well, here, of course, it may not be mentioned, but one thing, my lord, even though it is
Then
submitted,
how can it be a speaking order?
then lordship will interfere and revert it back, my lord. Within 7 days, we will pass an order, my lord, considering everything. Even
Thereafter, again, you will do the same thing.
why I am saying, my lord, that's why I am saying, my lord, can we go beyond our jurisdiction?
No, that is not my question.
Lordship will see, my lord,
Where
the
you have
representation.
considered it? Let the director come.
Yes, Lord. I will have an instruction, at least one opportunity
No,
will be given. If nothing comes up, my lord, I will leave it to your lordship, my lord. I will leave it to your lordship. Even the, my lord, whether those documents are considered or not, then I will have the instruction, my lord. And if, why I am saying lordship may not, my lord, take it otherwise. We cannot go beyond our jurisdiction. That's what I am saying.
No, I have already clarified it. I am not asking you to go beyond your jurisdiction.
My lord.
But the question is, after going through this speaking order, can it be said that speaking order where he had considered the documents furnished by him along with
Then,
the
my lord, I will have a
representation?
written specific instruction, my lord. If at all, my lord, this, if they have not considered it, they feel from the record that it has not been considered, we will withdraw it, we will file a, must give a fresh order. Let it be, my lord, after 3 or 4 days, I will have the instruction. On Monday or so, my lord.
Yes, madam, when you are going to file affidavit?
Lordship, because there is I need to obtain clarification, Lordship. As annex of 6 and.
For how many time you have taken adjournment?
1 week time, Lordship.
Pardon?
1 week time, Lordship.
So it was listed on 4/11/2024. You have taken adjournment. Thereafter, on 28/11/2024, it was listed. Someone else appeared and taken adjournment. And today, and after 1 week, again, someone will come and take adjournment. Is this the process?
Yes, Lord.
Hmm? Heard Mr. Arsidas, learned counsel for the petitioner, and Mr. Gogoi for the respondent number.
It is response 7.
Respondent number 7, and Ms. Kaur learned counsel for the respondent number 1, 2.
1, 2, 3, 4, 5, and 6. All the respondents.
Ms. Kaur learned counsel for the respondent number so submits that she may be granted some time to obtain necessary instruction in this regard. But the record reveals that on 4/11/2024, she was granted license to file affidavit in opposition. Thereafter, again, on 20th/10/2024, another counsel appeared for the aforesaid respondents and pressed for time for filing affidavit in opposition. And the same was granted. And today also, again, Ms. Kaur pressed for granting time to obtain necessary instruction. So, recess shall list the matter on Kobe when? Pardon?
Next Friday, Lordship.
16, Lordship.
16. 16.
Lordship, consider for the part hard lordship.
Yes, looking at the pattern, but at least if he gets the relief.
In the meantime, Mr. Gogoi, learned counsel for the respondent number 7, shall obtain written instruction as to whether in passing the speaking order dated 31/12/2020, the director, the mission director, SSA and RMSA has considered the annexers enclosed with the representation filed by the present petitioner to him.
Well, Lordship will indicate the date, 23/11/2020, the representation.
23/11/2020.
It is mentioned by the annexes, page 38 of the repetition. Because the repetition was also annexed along with the representation. At the bottom, on the left side, note before, copies of so and so, along with the annexes are in place.
Page number 38.
Yes, ma'am. Annexes 7.
Yes, starting.
Dated 23rd/11/2020.
Well.
Okay. Recessal is the matter as parted.
Master. 23. Lordship. Lordship, my senior is out of station today.
Who is your senior?
Mr. DCC Bukon, Lordship.
As agreed by learned counsel for both the parties, recessal is the matter on when?
Lordship, this honorable court may fix the matter on after winter vacation.
The month of January?
Yes, Your Lordship. In the month of January.
Recessal is the matter in the month of January.
24.
Please, Your Lordship, kindly the matter may be passed over for the time being.
So. 25.
Dr. Kajal, we have already submitted all the evidence, my lord. All the evidence.
the last occasion, my lord, he has submitted the evidence with the condition that evidence need not to go into in a second appeal. But, my lord, I would like to submit before your lordship, my lord, that second appeals are always required to be shown that whether there is any perversity in the first appellate court judgment. And if I can show that, my lord, then my appeal may be admitted. If I fail to do that, my appeal may be dismissed. But substantial question of law is required to be framed even for the dismissal also, my lord. So for that purpose, my lord, I would simply like to take your lordship to page number, my lord, 170. That is the appellate court judgment.
170.
170, my lord, yes.
Yes.
My lord, paragraph number 54, my lord.
Yes.
My lord, now may I read, my lord? Now arriving again to the instant dispute in hand, it is seen that
No,
condition.
Mr. Sutter.
Yes, my lord.
If there is no substantial question of law,
yes,
how can we frame substantial question of law to
That's what
dismiss
I'm
it?
saying, that if I can show your lordship that there is requirement to frame the substantial question of law, then it will be framed. And if I am not in a position to show before your lordship that there is no material to, formulate the substantial question of law, then my appeal will be dismissed. So for that
No,
purpose,
I am concerned with your submission that even for dismissal also, this substantial question of law has to be framed. But if there is
My
no
lord,
substantial question
my
of
lord,
law,
I'm not saying, that's what the Supreme Court is saying, my lord. That's what the Supreme Court is saying, my lord. And I will give a judgment to that effect to your lordship.
show it, show it.
Acha. Yeah, 1999, 6 or 6, 35. My lord, this head note B and C, my lord. Second, your lordship is right that if there is no material to show, then how the substantial question of law will be framed. Second, substantial question of law, framing of held is mandatory. Plain reading of section 100 makes it clear that High Court is required to frame a substantial question of law at the beginning of the hearing itself. Held, High Court's judgment in second appeal remanding matter to the trial court for fresh disposal without formulating a substantial question of law unsustainable and thus set aside. As B is, my lord, substantial question of law, it is obligatory upon the High Court to hear counsel for the parties on substantial question or questions of law raised in the memo of appeal. And only for that purpose, I wanted to take your lordship to that page number 170, that paragraph number 54 of this.
So how this judgment will help you?
My lord?
How this judgment will help you?
The judgment in hand of the lordship.
In this case, the High Court has remanded the matter.
Yes.
We
How-
are not in that process. We are not for remanding the matter.
No,
We
no,
are
no, of
only
course.
hearing on the existence of substantial question of
Yes, my lord, yes, yes.
yes.
My lord, paragraph number 54 at page number 170, my lord. Now, arriving again to the instant dispute in hand, it is seen that condition imposed upon Gunoda Bala Das, and that condition does not specifically says that it will also be applicable to the inheritors of the property after death of said Gunoda Bala Das. The condition is not appears to be specific about its applicable to the inheritors of the property donated to Gunoda Bala Das. And as such, the said condition is stipulated for the donee may not be enforceable on the inheritor, defendant number 1, for several reasons. Firstly, since the inheritor was unaware of the condition and it was not explicitly included in the gift deed as applicable to them, according to this code, may interpret that. Number 1, my lord. The condition was intended solely for the donee, and did not extend to the inheritor. The inheritor acted in good faith in selling the property described in Schedule D of the plan in favor of the defendant number 2 without being aware of the condition. Third, my lord, consequently, the sale to a third party by the inheritor would stand and the condition would not bind the new owner. My lord, so herefrom, what is deduced is that it may not be applicable to them according to this code. Reason being, since the inheritor was unaware of the condition. Last 3 lines of my lord, of this paragraph number 54. My lord, the learned trial court, I mean the first appellate court, has to come to the finding that the inheritors were not aware about the condition. Now, my lord, for once, say, page number 49, my lord, whether the inheritor was aware or not. Page number 49, my lord.
Page number
49, my lord.
Page number or paragraph number?
No, my lord, page number 49, which is the evidence which my learned friend has also submitted before your lordship. My lord, just skipping out.
No, Mr. Sutter, you first tell me, can there be any condition in a gift deed?
Yes, conditional gifts are also.
Is it the requirement?
My lord, conditional gifts are allowed.
Can you show me the provision?
My lord.
Show it.
My lord.
Right now you are not available.
Kindly give me some time, my lord, then. I can satisfy your lordship. Whatever the queries are made by your lordship, I know that it is based on some reason. I can satisfy your lordship that the conditional gifts are also valid. I will show to your lordship. Kindly give me some time.
Actually, there is a gift deed in which a condition is imposed not to alienate the property to one except to one particular person and his sons and daughters. That is there. So that is barred by section 10 of the Transfer of Property Act. Transfer of Property Act said that you cannot restrain the
Impose any
alienation.
condition.
Yes. There is a reason cannot be there. You cannot restrain the alienation of the property. So that is the main issue here, whether that is alienation can be done or not, whether if there is absolute restraint is illegal.
Barred.
Absolute restraint is barred. That is main problem here. Here.
No, first let him satisfy the court.
Yes, my lord.
He prays for some time. Do you have any objection?
My lord, if he prays for time.
As of date, I am no way gainer from any side. I can satisfy.
But I am being disturbed now. Since 2006, my lord, I have purchased a property and since 2006, a case has been pending against me. I cannot do anything with the property. That is main problem. I have purchased, the purchaser says that I have sold, the vendor says I have sold.
You are disturbed unnecessarily, but I am disturbed genuinely. My
No,
lord.
not genuinely. Okay. He has no right on the property. He is trying to establish some right. That is main problem is there.
Heard Mr. Sutter, learned counsel for the appellant, and Mr. Sharma, learned counsel for the appellant. Sir Sharma, no, Mr. Sutter pays for granting him some time to satisfy this court as to whether there may be conditional gift or not.
Yes, my lord.
Listen, okay?
You give 10 section 10.
12,
As well, bar of section 10 may be also. Conditional gift it as well as the bar of section 10. Both may be considered together. Otherwise, again, on that ground, again, there will be.
No, let him first.
The second week of December.
Hi. My lord, either 13 or
11 December.
11 to 1.
No, Mr. Sutter,
My lord.
this court will not sit till
No, my lord,
for
it
2 weeks.
should be before your lordship. ইমান এক্সারসাইজ করার পিছত যদি এই কোর্টে নুশুনে কোনে শুনিব?
Okay, then 16.
16. Let it be on 16. 16 Monday being motion day, my lord. 17.
It is the 25, 24.
नहीं इधर का है.
24 years.
Video. Okay.
November. December, no?
16.
16.
My lord.
Item 26 for orders.
Order
May I please, your lordship? My lord, the office note dated 13/11/2024. Where from my lord, it is reflected that no service report has been received, my lord. As far as the usual process is concerned, my lord. I could not take my lord registered post, my lord. I'm in such a property, my lord, below property line. Appellant, my lord, before your lordship. So I could not take the registered post, my lord. Now at this stage, my lord, service report has been awaited.
So we'll list it after 2 weeks, awaiting service report. Heard Mr. TEO Loskar, learned counsel for the appellant. Office note dated 13/11/2024 indicates that service report upon respondent number 2A Roman 2, 2A Roman 3, 2A Roman 4, 2A Roman 5, and Roman 6 are awaited. So list the matter after 2 weeks awaiting service report upon the aforesaid respondents. The learned counsel for the appellant submits that the appellant is living below poverty line and as such he could not take step upon the aforementioned respondents by registered post. List after 2 weeks.
Like 27.
May I please, your lordship? Lordship, LCR has been received, lordship. Lordship, matter may be-
Service completed.
Lordship. Thanks for that.
Both the parties are represented by their engaged counsel. It is submitted that service has already been completed and LCR has also been received and the matter is ready for hearing. Accordingly, it is provided that recess lays the matter on 2010 matter.
On 9th January,
Obliged, obliged, Lordship.
28.
Maybe, Your Lordship. We are newly engaged in this case, Your Lordship. We already, today itself filed Wakalatama. And as per last order, respondent number 2 step was not taken. I may allow to take first step on the respondent number 2, Your Lordship.
Your good name?
A. Hussain, Your Lordship.
Mr. A. Hussain. Learned counsel for the petitioner submits that he has newly been engaged. But your name appeared in the order dated 11/11/2022.
That's on that day, I am appearing on behalf of Mr. Amdhar. But in this right now, we are newly engaged as directly counsel, Your Lordship.
And he pressed for granting him some time to take sleep upon respondents. Respondent number 2. Pair is allowed. Step be taken by registered post with AD and also by usual process within a week from today. Place the matter.
2 weeks, Your Lordship. 2 weeks, sir.
2 weeks.
On 20 January.
That you Okay, within 2 working days from today. Place the matter on
20 January.
Obliged.
Item 29.
Lordship, the matter is a condemnation where there is a council named council in there as a caveator. We also tried to stress out, but could not find. So let the notice be issued.
notice. Press notice.
Yes, yes. But we could not find out for us.
Part Mr. A.C. Java, learned counsel for the applicant. Mr. Java submits that he will take precisely upon the respondent. Accordingly, it is provided that step be taken upon the respondents by registered post with AD and also by usual process within 2 working days from today. Place the matter after 4 weeks.
Item 30. My lord.
You are for respondent.
I am for the respondent number 1, 1 and 1, 4 and 7. Now, this matter, my lord, my submission is that this matter has become infractious in view of the judgment and order passed by the Lordship of the Honorable Court.
When?
CRPIO. This is, I am reading the order. That this very appeal in respect of which the present CRPIO was filed, that appeal has been held that it is not maintainable due to barred by law. So in view of that, this present CRPIO 406 of 2018, it has become infractious. Because the whole matter before this Lordship in the CRPIO concerning that title appeal. The title appeal has been held that it is not maintainable. This is the copy of the judgment, my lord, I am holding.
Yes. Subject matter of this CRP
is
and the appeal is was same.
Yes, it depends on the basis of very appeal. This title appeal that was, and the prayer portion in this C, prayer number C, if Lordship kindly peruse of this CRPIO. Because this, they preferred this appeal after they a delay of 3,883 days. They preferred the appeal after the judgment and decree was passed in 2007. And whereas they had the knowledge, in spite of that, after 11 years, they filed the appeal. And thereafter, that delay was condoned without highlighting, without considering the matters that it was in their knowledge. But thereafter, it came before this Lordship of this Honorable Court. And then Lordship of this Honorable Court, when examined all this, then found that this appeal is barred. It cannot be entertained, as it is reflected in page number 6. Page number 6 of that judgment and order. Now the last, from the bottom, it is second para.
But today the other side is absent.
That is my lord.
We fix a sort that. Let the other side appear. Thereafter we'll pass the order.
My lord.
None appears for the petitioner on call. However, Mr. Nandi, learned counsel for the respondent number 1.1 to 1.4 and 7 present. List the matter on. You keep this order with you?
Yes.
List the matter. So do we fix a date? Or after 2 weeks?
My lord, if it is 2 weeks, let it be after 10th December.
13 December.
Okay.
Again, 31.
Wait, please, Lordship. In this case, we have already taken step, Office Note 25/11/2024. But Lordship, no usual step was taken, only registered AD was taken. But neither AD cards nor answer notice have been received. Await service report on respondent number 3.1 to 3.4. And LCR of title suit and title appeal, Lordship, has not been received yet. LCR of title suit received, title appeal not yet received.
Heard Ms. R. Sodori, learned counsel for the appellant, and Mr. Rana for respondent number 1, 2, and 4. 1, 2, 4, and 5. 1, 2, 4, and 5. Office note dated 25/11/2024 indicates that notice issued to the respondent number 3.1 to 3.4. No, not 3.4. No, neither AD card nor answer notice issued in respect of our respondent number so and so returned till date. So list the matter after 2 weeks, awaiting service report upon the aforesaid respondents.
Lordship, and reminder may kindly be issued.
SSL also issue reminder to the learned First Appellate Court to transmit the LCR of TA number 13 of 2016 without further delay.
Deeply applies.
32.
May I please, Your Lordship? Lordship, this cross objection we have filed. On last occasion, the respondent sought time to file objection against this cross objection. But till today, no such objection has been filed. So I pray this matter may come in the column of Order 41 Rule 11 because the cross objection is yet to be admitted.
For?
I am for the respondent.
No, for?
In the column of Order 41 Rule 11 because the cross objection is yet to be admitted along with the connected IS.
Heard, Mr.
G. Bhadra.
Learned counsel for the applicant. This is a
cross objection appellant.
Mr. Bhadra submits that he has already filed cross objection. None appears for the respondent on call. List the matter. When?
11th of December if possible.
Okay, on 11th of December.
In the column of order 41.
Okay, in the column of order 41, rule
11.
11.
Ali.
35, sorry. 34. May please, your lordship. Order dated 24/09/2024, the matter was listed before the Lazima court. And order reflected that respondent number 4 and 5 service has already been completed.
How many respondents are there?
2, respondent number 4 and 5.
In respect of other respondents?
Lordship, I'm appearing for secondary education department.
Or Mr.
In Islam,
In Islam, learned counsel for the petitioner, and Madam Musahari, learned counsel for the
Secondary education.
secondary education. Order dated 24/9/2024 indicates that service upon respondent number 4 and 5 has been completed. Have you filed your affidavit?
Lordship, we have not filed our affidavit.
Are you interested to file?
Lordship will file our affidavit.
Ms. Musahari submits that she may be granted some time to file affidavit in opposition. Here is allowed, recusal is the matter. Well, after 2 weeks?
Lordship.
After 2 weeks.
35. May I please, your lordship? Your lordship, we have taken steps to trustee, your lordship, an affidavit has been filed. That effect, your lordship. Upon responding number 4, your lordship. If your lordship peruses the office note, your lordship. As per the office note, your lordship, dated 27/8/2024.
Mr. Borwa, you are for respondent number 3.
My lord.
And Mr. Bora,
Respondent 2, my lord.
respondent number 2. Who is for 1?
One is
School education.
education, is the department. Education কোনে করে গেল?
Heard, Mr. Your good name?
D.S. Tekka, your lordship.
Learned counsel for the petitioner. And Mr. Borua, learned counsel for the respondent
No,
number
three, my
3. And Mr. Kosik for respondent number 1.
One, my lord.
And Mr. Bora for respondent number 2. Office note dated 27/8/2024 indicates that service upon respondent number 4 is completed by Dustimut, and an affidavit has also been filed to that effect. And it appears that service of notice upon respondent number 4 was effected, but respondent number 4 remain unrepresented today. So, are you going to file any affidavit?
That first it is because Kitagata, this apps is to be filed, it is by department.
Being respondent is the college.
College.
Kitagata portal has to be corrected.
By him.
Reported by the petitioner, that correction has not been done. College is the main authority, main person who has to make the correction.
thereafter it will proceed to the department as well as the AG. That correction has to be made regarding age.
No, Bora, you come to this side.
You talk about the portal, there is a portal after retirement, you have to make all the online application for pension and all these things. That had to be corrected by the college. Where my petitioner is working. And that correction had to be done by the college. Here the college is the main respondent. College had to correct it, then it will be forwarded to the department, thereafter to the AG for getting the pension. There are some error in the, apparently in the date of retirement.
Your Lordship, may I just submit, Your Lordship?
No, that's all right, but respondent number 4 not responded.
Yes, Your Lordship.
Today only service is completed, you will appear, I think, next one.
No, service was affected.
Service was just was.
Yes, in the month of August.
Yes,
They should have appeared by now.
Yes.
They should have appeared. But the correction had to be done by the college. It's because there are some password and all these things are there. The college have to.
This is to be initiated by them, you know, day after it will go to director, then to government, then it will go to AG.
AG, yes.
And direct it cannot go from DDO or dispensation officer.
Yes, yes.
It is to go, it is like, if anything, that is to be corrected by the concern that the gentleman, that is 4 million. Now today is not appearing, next date.
Yes, what is your suggestion?
Your Lordship, in this instant matter, my provisional pension has been withheld only because of the very fact that there has been a discrepancy in the date of retirement. I was supposed to retire as per the Kritagota portal app on 28/2/2022, my date of retirement. However, I retired on 31st of March 2022, and accordingly, Your Lordship, because of my date of birth in the service book was entered in the year 1962, so I retired as per the service book record on 22, Your Lordship, 2022. And effective, my provisional pension was effective from 1/4/2022. Now, Your Lordship, I just communicated with the petitioner. There has been some initiation of process being conducted or proceeded with the department, with the principal. However, Your Lordship, the principal, the respondent number 4 till now has not entered appearance, Your Lordship. So I'm in a predicament situation because they would only have to submit before this honorable court whether there has been any initiation of proceeding been done, Your Lordship, with regards to my final pension and also for the provisional pension, because my provisional pension has been withheld because of the mismatch on the Kritagota portal app, Your Lordship. But as per the petitioner, he has communicated to me that there has been some initiation of process been going on, Your Lordship, between the department, which is the SCRT, and the principal, Your Lordship, in charge of Government Section Mahavidyalaya, Your Lordship. Until and unless they appear, Your Lordship, I'm in a predicament situation because they will have to.
According to him, this process is going on.
Yes, but
his own submission that principal is taking initiative for doing so. Yet some week, 2 weeks.
Yes, Your Lordship.
That may be fixed.
Yes,
Because
sir.
he also must have, maybe because my presumption that after doing correction, he will come and say to our Lordship that, oh, it is being corrected.
Yes, Your Lordship.
That's why after next day.
Yes, Your Lordship.
Because his own submission is that it
Yes,
process
Your
is
Lordship.
going on. Not stalls anyway.
Yes, Your Lordship.
10 days after 10 days.
Yes, Your Lordship.
Communication between the petitioner and the principal.
The petitioner has communicated to me, Your Lordship, that there has been an initiation of process with the department, which is SCRT, with the principal for uploading of my date of retirement or correction of my date of retirement on Kritagota portal app, Your Lordship.
Okay. The learned counsel for the petitioner submits that as per his instruction, some communication between the principal, the respondent number 4 with the SCRT is going on.
No, in the petitioner, not SCRT. SCRT comes later on.
The petitioner has informed me that there is a process going on, Your Lordship. The director has intimated some communications without any evidence on record. I may not be able to submit, Your Lordship.
No, Mr. Bora, I am recording his submission.
Yes, Your Lordship.
So he is going on. And as such, he prayed for granting him some time to obtain up-to-date instruction. He is
Yes, sir.
accordingly allowed. List the matter after 2 weeks or 1 week.
It will be after 2 weeks.
2 weeks, Your Lordship.
2 weeks. 2 weeks.
Your Lordship, if some informations in the form of an instruction received through me, your lordship, I'll be placing your lordship through an affidavit in
Ah, yes,
additional
alright.
affidavit. That also may be recorded, your lordship.
Not necessary, you can
Okay, sir.
file it. Liberty will remain with you.
Much
43.
obliged, lordship.
Lordship, here in this matter, may I be permitted to have a 2 weeks further time, Lordship, to obtain the updated instruction? Lordship, here Lordship, the petitioner will have to impeach the current incumbent, Lordship, because the contemner one, Lordship, he has been transferred 2 years back, Lordship. Now currently, Lordship, someone else is holding the post, Lordship, the post of Director of Higher Education, Lordship. So I'll give him the details, Lordship. In the meantime, he can implead her, Lordship, and I will get the instructions as well.
Heard, Mister?
It's the PH, matter of 2022,
Yes, learned counsel for the petitioner and Mr. Upamanya, learned counsel for the contemner. Mr. Upamanya submits that as per his instruction, the contemner has already been transferred 2 years back.
Yes, Lordship.
2 years back, and now new incumbent is there, and the petitioner has to implead him,
Her Lordship.
in this petition, and he will furnish details of the incumbent to the learned counsel for the petitioner. And price for granting him 2 weeks time, where is allowed, list the matter after 2 weeks.
Highly obliged, Lordship.
Well, the date means it's
On 18
December.
18 December.
Highly obliged.
44.
May I please, Lord?
Yes.
Actually, appeal has been filed. While filing the appeal, only 30 days delay has been caused, Lord. That is very marginal days, of course. We have
30
made the-
days?
Yeah, only 13 days, 13 days while filing the appeal. It is a condonation of delay matters, Lordship. If your Lordship please, I have given some explanation here because appellant is the retired school teacher. While doing his official job relating to the reimbursement of his or some official due from the office of the Deputy Inspector of Schools, Your Honor, then he could not take the certificate copy at the appropriate time. In a course of time, 13 days delay has been caused, Lordship. It is a very marginal days. Maybe condone, Lordship. There is a marriage in the appeal.
All right, let notice go at this, is this?
13 days, Lordship.
Let the other side appear.
We have given
Heard
the-
Mr. S.K. Sharma, learned,
S.K. Sharma, yes.
learned counsel for the applicant. This application under section 5
Yes,
of
section
the Limitation Act is preferred by the applicant for condonation of delay of 13 days
13
in
days.
filing connected first appeal against the order dated 13/6/2024 passed by the learned civil judge senior division Kamrup at Amingaon in Mijje case number 148 of 2023 in connection with arising out of title suit number 96 of 2023. That notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. So, both the respondents are from Guwahati.
Yes. Both of them are.
Serves
Yes, Lordship.
notice by Dusty mode also. We will permit you.
Lordship, actually another post and address is there. Gauripur Sangsari is also there. Their site address is there. Where works is going on there, right? The site address. That's why both way service may be necessary.
Pardon?
Both way, usual way as well as the,
Both. And Dusty mode also permitted.
yes.
You may take it or may not take it.
Yes.
45.
Place the matter after 4 weeks.
Okay.
45.
Wait, please, Lordship. For this application, Lordship, we have filed for recalling of the order, Lordship, at page 17, Lordship. What happened actually, my lord, due to certain misinformation, my lord, is 17, my lord. The matter- Recalling of this order. My lord, this matter was declared to be infructuous on my submission that the cause of action is not surviving anymore.
what happened actually, my lord, since 2016, the matter was not listed. My colleague who was there on record with me, he died in the years 2022, August 2022. And he was in directly contact with the client fellow. Now, on the date when it was listed on 31/7, we tried to gather the information from the e-court status, my lord. Your lordship will kindly find page 15, my lord. The e-court status reflected that the matter is disposed in the civil court in 2017 itself. And therefore, my lord, this submission was made that there is no cause of action alive. Your lordship will kindly see page
Now,
15.
thereafter, what happened?
Thereafter, my lord, after it is disposed, now the petitioner, they have received a summon from the civil court, my lord. It was wrongly been reflected in the e-court status as disposed in 7/1/2017. All along these years, my lord, this matter was neither listed here and there was no information from the petitioner, my lord.
And that's all right, but since this order is for recalling, the
Just praying for restoration of the
presiding judge who passed the order is available in this court. Perhaps it has to be listed before that court. Come in. When?
28 minutes.
This month.
20. Tomorrow.
This month.
20. Tomorrow. I just pray for restoration of this.
You file a petition before the trial court. That one civil revision petition is pending before this court.
My lord.
No, not civil revision petition because
CRP is disposed. And there was actually, there was
in fact, there is no petition
yes.
before this court, but one IA is pending. You inform the court to defer the matter.
I'll try that. Otherwise, the CRP, there was actually a stay order operating.
Lord Mr. B. Kosik, learned counsel for the petitioner. This interlocutory application is preferred for recalling the order dated 31/7/2024. Rest shall list this application before the appropriate bench.
It can be on 1st of December. Monday.
1st of December is holiday.
Monday, Monday.
2nd December.
First is Monday.
Mr. Kosik submits that there is urgency in this application.
Oh, sorry. 2nd.
Yes, the next date is fixed before the learned trial court on
28 Monday.
28.
29. Sorry. 29. Let it be on 2nd Monday.
29. Accordingly, it is provided that recess shall list the matter before appropriate bench as early as possible.
Good.
Pending item 24. Item for hearing under order 41, rule to CPC.
Make the lordship. In this case, lordship, the appellants are the defendants, lordship. He is a defendant, the suit for specific performance of contract. Lordship, kindly see the plaint, page 6, and I have formulated the substantial question of law in page number 4. There was no lordship readiness and willingness on the part of the plaintiff, lordship. There was no such pleading in the plaint, lordship. That was
No, that is a question of fact.
no lordship readiness.
How the court will this court will determine
Section
is there
16C
any
of specific relief act, lordship. Section 16C of specific relief act, lordship. This is a mandatory provision, lordship. There should be readiness and willingness on the part of the plaintiff.
No, that is there, but who will ascertain it? But the trial court.
Yes, lordship. There was no such issue framed by the trial court, lordship. That is one ground. So accordingly, we have taken that ground before the learned first appellate court.
Whether
Yes,
there was
yes.
any point for determination?
Yes, lordship. Thereafter, point for determination was formulated. First of all, lordship, page 22 trial court judgment issued, Lordship. And this is a Lordship mandatory issue, Lordship, whether there is readiness, willingness on the part of the plaintiff, section 16C of specific relief act, Lordship. Issues, is there any cause of action for the suit, whether the suit is maintainable in its present form, whether the suit is barred by limitation waiver, whether there was an agreement for sale between the plaintiffs and the defendants whereby the defendant agreed to sell the suit land to plaintiffs and received ₹4 lakhs in advance from the plaintiffs, whether the defendant failed to register and execute the sale deed in favor of plaintiffs after getting NOC, and whether took any steps for measuring the land and fixed the quantum of the agreement dated 4/2/2017. In fact, this is the second date of agreement, Lordship. First date of agreement in the year 2016 that was suppressed by the plaintiff in his plea. And second deed was executed incorporating plaintiff number 2. First deed he could not, Lordship, he could not do his part, so that deed of agreement was never responded to by the defendant. So after that, again in the year 2017, another deed of agreement was Lordship executed between plaintiff and defendant. And thereafter also they remain silent from the amount, the rest of the consideration amount, Lordship. And in plaint, your Lordship will find page 6. There was no such averment there that they are always ready and willing to purchase the plot of land. A substantial question of law. And moreover, the
No, whether that aspect was dealt with by the trial court in judgment, though it has not been it has not framed any issue on that point.
No, Lordship, that on issue number 1 is cause of action, maintainability, then barred by limitation, and issue number 4, Lordship, page 24. The issue relates to the factum whether
How the first appellate court has dealt with the issue
point was formulated, Lordship.
on that point?
Yes, Lordship. That is there.
Page number?
Page 48, Lordship. Four points were formulated by the learned first appellate court. First point is whether the learned trial court failed to consider the fact that the plaintiffs were never been ready and willing to get the sale deed executed.
How this question was answered?
That is page 17, 1 paragraph and discussion, Lordship. 14, it started. Point number 1, page 50, Lordship. 14.1, as the point number 1 pertains to section 16 of the Specific Relief Act 1963, for ready reference, the said provision is reproduced herein. The Lordship will find last paragraph, who fails to prove that he has performed or has always been ready and willing to perform the essential terms of the contract, which are to be performed by him, other than terms of the performance of which has been prevented or waived by the defendant. So this is most important part on the part of the plaintiff, and learned first appellate court held discussions in Lordship page 56, 17.4. The case of Supreme Court was relied on, and I am also relying on this citation, Lordship. In the case of UN Krishnamurthy, and so while dealing with the matter of a specific performance of contract, the Honorable Supreme Court of India held in a suit for specific performance of a contract, the court is required to pass unto itself the following questions, namely whether there is a valid agreement.
No, you come to the finding of the court.
Lordship. Paragraph 18, page 57. On meticulous scrutiny of the record, especially the evidence, it would reflect that the plaintiffs have made repeated demands to the defendant to execute the sale deed, but on one pretext to other, it is the defendant who delayed the matter. The PW1 in his evidence in chief has reiterated the same and in his cross-examination has retained the stand taken by him. The defendant side could not rebut the evidence adduced by the PW1 pertaining to his readiness and willingness. The suggestion given to this witness was denied by him. Explanation 1 of section 16 of the Specific Relief Act does not require payment of the money or deposit thereof to the court. What the plaintiff is required to prove is that he was really ready and willing to perform his part. But this specific pleading is absent in his plaintiff. The defendant side contended that the plaintiff did not issue any formal notice upon the defendant asking him to execute the sale deed. So we raised another point that he never served a notice demanding to perform the rest of the contract portion. In a dispute which this court is dealing now, there is no rule in evidence that a notice must always be in written form. The plaintiffs reiterated that they made repeated approaches to the defendant with a request to execute the sale deed within the stipulated period by taking the remaining amount, but it is the defendant who did not come forward. Since the agreement for sale is a reciprocal arrangement between the parties, the defendant was also duty-bound to inform the plaintiff to pay him the remaining money and to come forward to get the sale deed executed in their favor, but there is nothing in the record that the defendant never made any communication with the plaintiffs to that effect. Moreover, there is nothing in the record to indicate that the defendant has ever challenged execution of Exhibit 1. So the burden was shifted on the defendant, but it is settled principle of law, as your lordship is aware. Plaintiff has to prove his own case, lordship. Then onus will shift to the defendant, lordship. But it is the plaintiff who came to court seeking a specific performance of contract, lordship. So my substantial question.
So First Appellate Court has dealt with the issue, though no specific issue was framed on that point, and besides, that is a question of law.
Lordship, that is the perverse finding that the defendant failed to prove that part, lordship. It is the plaintiff who is required to prove his case, lordship.
No, that's all right, but where it is observed?
Lordship.
The defendant failed to prove?
Paragraph 18, 1 last 4-5 line. The defendant was also duty-bound to inform the plaintiffs to pay him the remaining money and to come forward to get the sale deed executed in their favor, but there is nothing in the record that the defendant ever made any communication with the plaintiff.
No, that is not in respect of the issue you have pointed out.
That is, lordship, plaintiff has to prove his own case, lordship. That is a substantial question number 3. Whether the findings arrived at by both the courts below are correct in decreeing the suit of the plaintiff in absence of proof of plaintiff's case, despite being the settled principle of law that the plaintiff has to stand on his own footing.
No, that is always there, but can it be said that the First Appellate Court has shifted the burden to the defendant? That the plaintiff is ready and he is always willing to perform his part of his contract, where it is observed.
It is stated that the plaintiffs reiterated that they made repeated approaches to the defendant with a request to execute the sale deed within the stipulated period by taking the remaining amount, but it is the defendant who did not come forward. Since the agreement for sale is a reciprocal arrangement between the parties, the defendant was also duty-bound. So the burden was...
No. That cannot be interpreted in that way.
Also duty-bound to inform the plaintiffs
Inform to pay him the remaining money.
Yes, lordship. So the burden
it is not it does not amount to shifting of burden.
It says that lordship, defendants are to take step. Lordship, it is a suit of the plaintiff. He has to take step for proving or lordship performing his contract, lordship.
Okay, we'll fix it for further hearing. Ms. R. Sothuri, Learned Counsel for the appellant, lists the matter on for further hearing.
18 December, lordship. Applies, lordship. Last week of, before vacation, it will be the last week, maybe the
Oh, you
entire
can take any date,
motion.
Hmm.
Public.